Needham
Recording in
Planning
progress.
Board. It is Tuesday, January 4th, 2022. Happy New Year to everyone who can hear my voice. This open meeting of the Needham Planning Board is being conducted remotely, consistent with current state regulations, and is being recorded. Public access to this meeting does not ensure that there will be public participation unless required by law. This meeting will not have public comment except in connection with any hearing that is on the agenda. There are no hearings on tonight's agenda. First, we will confirm that a quorum of the members of the planning board are present. When I call your name, please respond that you are present. Jean McKnight.
Present.
Adam Block.
Present.
Marty Jacobs.
Present.
And Natasha Espada.
Present.
And the chair, Paul Alpert, is present. Next, I will introduce the planning department. We have Lee Newman, our planning director,
Present.
and Alex Klee, our assistant planning director.
Present.
Okay, so as each agenda item is reached, I will introduce participants who are here to present or discuss projects and proposals. For those participating in the meeting, please also be aware that others may be able to see you and hear you. Anything that you share or state will be a matter of public record. All supporting materials for this meeting, including the agenda, are available on the town's website, www.needhamma.gov, unless otherwise noted. Meeting ground rules. Ground rules for this meeting are designed to allow for an accurate public record. Each of the speakers on our agenda will be introduced. After speakers conclude their remarks, each board member will be asked by name for any comment, questions, or motions. All votes will be by roll call. Each participant, please remember to state your name for the record before speaking. For each person from the public who is recognized to speak, please remember to state your name and address for the record before speaking. That concludes our introductory remarks. The first item we have on our agenda is a discussion regarding a zoning review of a proposed medical use for a major project site plan special permit number 2005-07, Needham Gateway LLC, with regard to property located at 100 and 120 Highland Avenue, Needham, Massachusetts. And I see that we have participants here. Rick Mann, Richard Mann, the attorney for the petitioner, and Mike Moskowitz, who I assume is the petitioner.
Look how he appeared just on cue.
There we go.
Well done.
Rick, you have the floor. Well,
Thank you very much. I want to first, my name again is Rick Mann. I'm an attorney. I represent Needham Gateway LLC. Needham Gateway is the owner operator of the Needham Gateway Shopping Center. I want to thank, first of all, I want to thank all of the members of the board and Lee and Alex for allowing us this period of informal discussion before we file what I hope to be doing shortly, file an application for a special permit amendment to our existing special permit. As I believe you all are aware, particularly based on the last hearing we had on this center, which was just in July, this center exists pursuant to a special permit issued back in 2006 for a major project, site plan review special permit. It's been amended numerous times. The last time, again, in July, when we appeared before this board looking to broaden the uses, actually by way of retracting some of the formerly prohibited uses that were set forth in the original special permit decision. At that time, if I'm sure you all recall, we had a discussion about the change in the retail world that we're all experiencing. Both the internet as well as COVID have been a 1-2 punch to a lot of retail centers around the country, indeed the world. And Needham Gateway has been a victim of that, as well as many others. So we have 3 vacancies that will be coming up at the end of March. One is the FW Web site, which is an entire building of the 2 buildings that comprise the center. And the others are Omaha Steaks and Supercuts. In order to fill that, we've been out looking for tenants for months now, and we have two prospects, one of which we want to discuss this evening, the other of which I believe you're aware of, which is the ex-golf. I know I've discussed this with Lee Newman before, as well as with Commissioner Roach, at least in part. And we'll be back to you within the next 30 days with a formal application for a special permit amendment for that use, as well as what we hope the one that we want to discuss tonight, which is Carbon Health. So Carbon Health is a company which provides a basic primary care and walk-in care services, medical services. It is owned by a single physician, which takes it out of the realm of Chapter 111, Section 51. It does not need a state license as a clinic. That brings us to the question of what is it under the bylaw in Needham, which is not an entirely easy question to answer since there are numerous definitions that are involved. I had a discussion with Commissioner Roach and Lee Newman a week or two ago, which culminated in a letter being signed by Commissioner Roach, which I believe you have in your package. In that letter, Commissioner Roach looks at all of the definitions that are applicable to this issue and concludes, I think correctly, that the use is technically a professional office, which is allowed as a matter of right in the Highland Commercial 128 district in which these premises are located. Commissioner Roach and I believe Lee Newman as well, wanted us to have a discussion with this board before proceeding further, just to make sure we were all on the same page on this pivotal issue. I will tell you that were it not for the conclusion reached by Commissioner Roach, we would be in a position of having a prohibited use, not a special permitted, but a prohibited use. I also think it's important to note that notwithstanding that it is indeed, I believe, a permitted use, we will still need to come back to the planning board for relief in a number of different ways, most particularly because we have the benefit of a parking waiver under the existing special permit, and we will need to come back to you basically to get your approval for a continuation of that exemption based upon this new use. So it will not be that the planning board will lose any jurisdiction, but it does make a difference in terms of our ability to proceed with this use, that we're all on board relative to this determination that has been made by Commissioner Roach. Rather than go through the definitions, although I'm happy to do it, I will presume that the members of the board have read the letter. Be happy to entertain any questions that you might have about it. I believe that it is an accurate interpretation of, again, a number of separate definitions that altogether, by process of elimination and otherwise, lead to the conclusion that this use is indeed a permitted use in this district. That being said, are there any questions by members of the board?
Yeah, Rick, I'm not convinced that this isn't a clinic that is subject to licensure under Chapter 111, Section 51. And I'm going to want to see a narrative in the file explaining why it's not, because our bylaw is clear that a clinic that is required to be licensed is not a permitted use. And this is a very complex and complicated situation where we're dealing with a foreign LLC. It's not a Massachusetts LLC. I'm sorry, it's a corporation. This is a Florida corporation. It is registered to do business in Massachusetts. But I'm not convinced by looking at Chapter 156A, Section 17, that the filing is necessarily correct. It appears to be owned by an out-of-state practitioner. I see the definition of clinic in 151, in chapter 111, section 52. I see the exclusion for solo practitioners, but if he's not licensed in Massachusetts, he's not the solo practitioner. So, you know, before I can understand that this is not a clinic that's required to be licensed, I need to have you
Sure.
put that together for us.
Sure. No, I appreciate that. It admittedly is not, sorry. I'm sorry, Paul, I cut you off. I apologize.
No, that's quite all right. I was done.
Yeah, before I respond, you had a question, Adam?
Thank you. I did, but I'll let you respond to Paul first.
Yeah. So you raise interesting questions. I don't see anything in the statute 111 that deals with the question of the licensure or the state of licensure of the individual physician. But that is something which I will look into with Healthcare Council. You should know that this company is seeking similar approvals in other communities in Massachusetts, and the issue of whether or not they are a clinic for purposes of Chapter 111 is a pivotal issue to them, and they have been proceeding with other communities, which is not to suggest that these are not legitimate questions, but I think that there are answers to them, and I will do my best to get you a response.
Good. That's really the only issue that I see. I mean, if you can convince us that it's exempt under Chapter 111, Section 51, you're only going to have one or two doctors here, which is the basis of Dave Roach's letter, then it seems to comply. Adam?
Did you have a question?
Thank you. So just to the point of the staff, there's 8 staff and up to 2 would be physicians. What are the other 6? They're not nurses?
Yes, you'll have nurses, you'll have physician's assistants from time to time. Let me back up and tell you, there's probably going to be as many as 14 people on staff, but they will not be full-time equivalents. They will be floaters. So they will never have more than 8 people at any time. And they're willing, by the way, to include such a cap on the number of employees in the special permit, just to give assurance to the town. But yes, there will be paraprofessionals as well, nurses, et cetera.
Do you have an idea of what kind of testing? Will they have X-ray machines? Will they have EKG machines? Will they do operate blood tests for type 1 diabetics and others?
Yeah, they will definitely be. There is a small lab included in the floor plan layout. So they will definitely doing some blood tests. I don't know for certainty about EKGs, although I suspect that they will be doing them. Bear with me one second. I'm looking at the floor plan to see if it gives me a hint as to the layout. So they definitely have a phlebotomy section and a lab, which just supports the fact they are going to be doing blood. They wouldn't necessarily have a separate room for an EKG. They would for an X-ray, and I don't see any X-ray on here. So I don't know the answer to that definitively, Adam, but I don't see it on the floor plan. Mike, do you know the answer to that? You're on mute.
No,
Yeah,
no,
okay.
I do not know the answer to that, but I will just add one other comment that and again, I understand you're asking us to answer these questions, but Carbon Health does have at least one location. They have a location in Chestnut Hill in Reading, and they may have another location.
Yep.
Okay. Thank you. I may have some additional questions at the time, obviously based on the particular application that you have in terms of the relief that you're requesting. I do, like Paul, wonder the extent to which, if this quacks like a duck, looks like a duck, smells like a duck, what kind of a bird are we dealing with?
I think it's a
Yeah.
turduckle. A
What's
that?
turduckle. Isn't it called, what is it, a turduckle or a duck turkle?
Turducky,
Thank you. Thank you.
exactly. So, so like Paul, I'll be interested in those additional materials.
Sure.
Yeah, I mean, I'm willing to point out to you where I'm concerned, because I'm looking at the definition of clinic in chapter 111, section 52. So it
Mhm.
starts out by defining a clinic, and it sounds like a clinic. And then it says, but a clinic shall not include one or more practitioners engaged in a solo or group practice, so long as such practice is wholly owned and controlled by one or more of the practitioners so associated. So I'm wondering where a Florida doctor is one of the practitioners so associated in the group that is performing the medical services here, and how that.
I think
how that works.
unfortunately, the language of the statute, and Adam, this goes to your point about the duck as well. I mean, it's all a question of what the actual language is. We have to live and die by it. And there is no definition, unfortunately, that I saw in 111 or have seen in 111 as to what the words so associated mean. But I grant you that these are legitimate questions. And again, to Mike's point and to the point I raised earlier, they've had to confront this issue in many other locations, and they've come out with their conclusion. Presumably, their analysis has gotten into some of these questions, Paul, and I will.
And maybe they've gotten an opinion from the licensee.
Yeah.
Which would certainly solve the problems.
Yeah, I will look.
Are they going to be affiliated with any other medical facility or clinic? Are they going to have relationships with BI or?
No, they're not.
So it's a private healthcare office that.
Yes. Yes. No affiliation.
And if they, if they're doing primary care, and for instance, someone is diagnosed with, a disease that requires a specialist, an endocrinologist, urologist, whatever the case is, they're not connected to a referral network or anything?
It's a good question whether they have their preferred network of referrals or not. I don't see any evidence of that in any of the materials I've read about the company's operations, though.
Okay. Jean, you have any questions?
No, I very much appreciate, Paul, the research that you did, and I think you're asking the right questions, and look forward to hearing the responses.
Thank you. Marty, you have any questions?
And not beyond what you've asked, except for this one thing, Rick, really out of curiosity more than anything. Is the intent to operate like an urgent care clinic?
Yeah, walk-in clinics basically, or nomenclature is a little odd in this whole situation, but yeah, I would characterize it in that way.
I also, just like Gene.
Like a care well.
I'm sorry? Like care well?
I would imagine it will be like a care well.
Okay. So I would simply say that if you can satisfy the question that Paul has asked, I then would agree with Dave Roach's reading of the bylaw.
Yeah, I'll just take the opportunity to just make one political statement if I could. It seems odd that we're faced with a choice of either having an allowed use or a prohibited use. It ought to be a special permitted use. It seems to me, which unfortunately there's nothing we can do about, but I'm left in a position of having to argue this, from the specific language, which fortunately provides a pathway to get where we need to be, subject to Paul's good questions.
Yeah.
Also, I was just curious, how is the medical waste discarded or removed from the site or treated?
I don't know, Adam. I think that's it's a question that you'd want to ask if we get to the stage of filing the application and at the hearing. But certainly there are laws that apply to the disposition of waste that they'll have to comply with, and no
Sure.
doubt do comply with.
Yeah. Adam, we really need to leave the specific questions of the operation to a point where we actually have an open hearing.
I understand. Okay.
Yeah.
Yeah.
Thank you.
Natasha, do you
Well,
want to?
again, I want to thank you very much for the opportunity, and I will get back to you addressing the points that you've raised.
Great, thank you.
Appreciate it very much.
Thank you. Mike, good seeing you. Rick, thank you. Good to see you.
Thank you.
Thank
Thank you,
you.
gentlemen.
Thank you all.
Okay, next item on the agenda is a transfer of a special permit to an affiliated entity. Major project site plan special permit number 2011-01, Wingate Senior Living of Needham, Inc., 63 Kendrick Street, is the petitioner for the property located at 235 Gould Street in Needham. You have anybody here on that?
No, I didn't think it was necessary to have them here. This is
Okay.
just basically, our decision requires that in the event that there's a transfer to an affiliated entity under their control, that they need to notify us of that transfer. And they have so done that. And I just wanted the board to be aware of it. And I wanted to ask the question as to whether or not you'd like something recorded at the registry which recognizes this transfer.
Yes, Jean?
I have a question because there seems to be a discrepancy between two separate letters from Jonathan Scharf of Wingate, one dated December 13th and the other dated December 17th that are in our packets. And the December 17th letter says that a transfer of it names the grantee of the special permit as Wingate Senior Living at Needham, Inc. Then it says this is about a transfer of the special permit to an affiliate entity under common control, and that being WSL Needham ALILOP LLC. Okay, that's what the letter says. Then the letter of December 13th says that the developer proposes to sell the project to EPC Wingate LLC. Completely different name.
The property, I mean, there's a difference here, I think, between the owner of the property and the entity that's going to operate the facility. So I think the letter of the 13th is speaking to the actual owner of the property. The letter of the 17th is speaking to the entity that's going to operate the facility. Our permit was not linked to the property owner.
Okay.
It was linked to the operator of the facility.
I see. Okay, thank you for that explanation.
So the new property owner, the company that's buying the property itself, is Well Tower, which is the property that owns in Avery Square.
Okay, now I see the phrases operator on the 17th, letter of the 17th, and owner on the letter of the 13th. I hadn't caught that before. Thank you.
Okay.
So, and we're approving both things, or is it?
No,
Is it
the other piece was basically a change in the arrangement that on the affordable units, because there was a contract with the state under the LIP, so the town needed to sign off on that as well, and that was done independent of you.
Okay. So we're not really approving either. It's just that they are required to notify us of a change in the operator.
Yes.
Okay.
Lee, was your question intended to find out whether we wanted the original of our approval of the transfer recorded?
Yes, my question was, we have a decision on record which issued it, I think, to, Wingate Senior Living as the operator, and now they've notified us that there's a new operator. I guess my question is whether or not you want something on record that now recognizes this new entity.
Or that recognizes that we received the notice?
Yes.
I can't see any good reason not to do it.
Mhm. I would think it would be the owner or the operator who would want that. And would
Okay,
be,
well then I can follow up with them and ask them to put them in a form that we can approve for that purpose.
Lee, I have a couple of questions then. I'm confused about what the operator is operating. Is the letter of the 17th, is what we're approving the operator of the nursing home or of the residences that are behind the nursing home?
The residents that are behind the nursing home.
Ah, okay. I misunderstood that. I thought the letter with the change of the operator was for the nursing home. Okay, so it's for the residences. And so the only issue on the letter of December 13th about the change of ownership of the property, because they talk about a project and a developer, which is confusing if all that they're doing is changing ownership of the landlord. So they're not really changing the operations with the change of ownership to Welltower?
They've represented that the operator is going to remain the same as was the operator under the base permit.
And that and they've also acknowledged that they're obligated to and will continue to adhere to the conditions of the various special permits.
Yeah, is that a condition of our special permit that a new operator needs to confirm to us in writing that they've read the special permit and will conform?
No,
It may not be required, but they have this assignment and assumption of regulatory agreements. And in those recitals, they acknowledge that they will, that they're going to adhere to all of the requirements of the special permit.
Okay, thank you, Adam. Okay,
and
yes,
excuse me, just have a question. I misunderstood that because two addresses were referred to, the Wingate residences at Needham and 1 Wingate Way. And I misunderstood that they were talking about both the nursing home building and the other newer buildings. But I guess the other newer buildings have two addresses or two.
this is not related to the nursing home. The 17th letter I guess the letter, I think the letter on the 13th is dealing with the affordable housing units, which are not in the nursing home.
But
They're
no,
located
I was looking at the assignment and assumption of regulatory agreements.
those
And
relate to the affordable housing units.
that does too?
That's what that's dealing with. It's dealing with the affordable housing units that are covered under a LIP program with the state.
Okay. Looking at it for a definition of regulatory, a certain regulatory restrictive covenants. Oh, okay. Okay.
Those are for the affordable units, which we qualified as LIP units so that we could count them as affordable units toward our 10% requirement.
Right. But all of this has to do with the property at the back off Gould
Yes.
Street at the back.
Yes.
And there are two buildings, I guess, mentioned, but doesn't have to do with their nursing. Okay.
Any other comments or questions, Marty or Natasha?
No, not from me.
Okay, where their only obligation is to inform us, do we need a vote? They've performed their obligation. They've so informed us.
Right.
Okay.
And I'll ask them to record something at the registry so that there's a record of it.
Great.
With evidence of the recording to us.
Yes.
Okay, that concludes that matter. We'll now move on to the third item on our agenda. Excuse me. My New England background has come out. Board deliberation of the major project site plan Needham Enterprises LLC. with regard to the property located at 1688 Central Avenue, the proposal to construct a new childcare facility that would house an existing Needham childcare business, Needham Children's Center. So I have turned this over for our vice chair, Adam Block, to be the chair of this matter. So Adam, I hand the gavel over to you.
Gavel received.
And
And-
Adam, I will be recusing myself. Thank
I
you. I'll
was
be
just
back.
about, thank you very much. We'll send you a text to come back in
Okay,
or finish this section. Thanks, Natasha.
thank you.
Thanks, Natasha.
So, we have our catalog of, of issues to deal with, and then we can just go right on into it. Have you had a chance to review the work product that the town council had prepared?
Yes,
Yeah, it's very helpful.
indeed.
I thought it was too. I'm glad that you guys did as well. And so, that can help guide some of our discussions. Do you want to start? Where would you like to start? Do you want to deal with some of the smaller issues like parking, or do you want to deal with, jump right into setback or other issues?
Here's where I'd like to start.
Yeah.
I'd like to have a discussion about whether building a separate building, non-residential building on this residential lot where there already exists a non-residential building is in violation of our zoning bylaw or not.
Start there then. I think my understanding, and you raised an excellent point, as was brought up by Holly when in her submission, questioning the extent to which the barn is truly accessory, as we define accessory as being a customary.
Let me go back, okay? Because I want to be focused on this because I don't want to spend too much time on this. But here's my real question. I think, can we all agree that the section that we're talking about is on page 31, section in the use table? Let's make sure we're all focused on the right thing.
Page 31, did you say?
Yes. Next to last use category on that page.
Marty, I think it's a combination of that and the accessory use, which is on page 33.
Let's start with 31.
Yep.
So let's just look at 31. And I'm going to ask the specific question with regard to the next to last use category on page 31. Does anyone here believe that having two non-residential buildings on a single residential lot is allowable based on page 31? Does anybody think it is?
I have to combine it with the accessory use on 33, because are you going to say that, forget about the barn. Are you saying that a non-residential use on this residential property cannot have a detached garage? Cannot have a separate shed on the property?
If it's a non-residential building, would those items be non-residential buildings?
They're separate buildings.
And then
They're not residential. Nobody's living in them. They're using it for storage. They're using it to park cars.
Right?
They're using it
Yeah, as residences.
for permitted accessory uses. And I specifically said sheds and garages because that's what's allowed on page 33. Customary and proper accessory uses such as but not limited to garages, tool sheds, greenhouses, and cabanas.
So you don't want to answer with regard to what's on page 31 alone.
I think they have to be read together, and it raises the question of
Okay, so you're looking and on page 30,
which one negates the other. They're contradictory.
on page 33, you're looking at the last use category on the page,
Correct.
right?
Correct.
Other customary and proper accessory uses such as but not limited to garages, tool sheds, greenhouses, and cabanas. So what, you're right, I focused on the word customary.
Yep.
What's your argument as to how that changes what I think is pretty clearly the reading of the use category on page 31?
Well, we've got an opinion from Dave Roach that he thinks that the accessory use provision trumps the two non-residential building.
Okay, let's go back. He doesn't say that. He only talks in his December 7th letter about use. He doesn't say anything about buildings. So my focus is on the buildings now. I'm not talking about use. He doesn't say anything about the buildings. And my reading is of page 31 is if you got two non-residential buildings on a residential lot, that's a no-no, can't do it. Period. Buildings. He doesn't say otherwise. He talks only about use. Why am I wrong?
You're not necessarily wrong. I'm just pointing out that we have two provisions that I think are contradictory. I don't think they can both exist on this lot. Either it's an accessory allowed building or it's a non-allowed second non-residential building. And we have to decide which one takes precedence over the other. If this was my argument last time, if we equate a 2,500 square foot barn with a garage, a tool shed, a greenhouse, or a cabana.
But
I'm
this
not
goes-
necessarily saying that, but then we get to the next argument, which is that enforcing this provision on a chapter 40A section 3 use,
Is not one of the items that are listed in 48 section 3 that
it's
take-
not, but it's an unreason. The argument would be that we are forcing them to take down the barn is an unreasonable regulation.
Before we get to that, Jean, you had a comment or question?
Yes, and where I was going was in the second sentence that Paul just gave about the concern being that we cannot prohibit. And I'm looking at the very helpful chart that our town council put together where on each page he lists the chapter 48, section 3 exemption. No zoning ordinance or bylaw shall prohibit or require special permit for the use of land or structures with an S, et cetera, or the expansion of existing structures for the primary, accessory, or incidental purpose. So if we interpreted our zoning bylaw to prohibit under the more than one non-residential building or use on a lot, we'd be doing exactly what is prohibited by the state law. So
Except,
I don't see how we can apply this section, even if we determine that it is applicable, we are unable to apply it.
but Marty raised the point last time that, as Holly had, that our definition of accessory relates to the customary use. And whether or not Holly's submission was exhaustive of all of the childcare facilities in town and other area towns. I think the conclusion is fairly similar, that they don't have a 4,500 square foot building, or by footprint 2,500 or so square foot structure customarily for these daycare centers.
It's a point that
And-
Marty made last time.
Exactly.
Well, I think that's a different question. That's whether the barn is is accessory to the daycare and therefore cannot be prohibited. But Marty was asking, I believe Marty was focusing on simply on whether it's two non-residential buildings on the same lot and thus prohibited. And that's
Yeah,
what I
Paul-
think we
But
cannot
Paul,
say.
Paul is linking them
So
through.
why don't we move on to that
the
issue?
use of accessory.
If we're satisfied that we cannot apply the two residential buildings on a lot, move on to the other issue of
Why should I
accessory.
be, why am I satisfied with that?
Yeah, I don't think
I'm
that
not
we are.
understanding your argument,
Sorry.
Gene. Tell me
Sorry.
why I'm wrong about that.
No, I agree with, I'm agreeing with Marty for now. Because we get back to, and I think town council's chart supports this, that the cases specify that whether enforcing our bylaw creates an unreasonable regulation is a matter of fact, that if our decision is appealed, the judge will decide, and the burden of proof is on the petitioner, that our enforcing our own bylaw is an unreasonable regulation.
They have made effort to do that.
They've made effort to do that, but we're not necessarily convinced that they're right.
Correct.
And if we feel that enforcing this bylaw is reasonable, we can enforce it, and they have the right to appeal it and get a judge to disagree with us.
And just as a little amendment to that, if that's the way we feel, we can require the removal of the barn in the context of an approval with conditions. One of the conditions being the barn's got to go.
Yeah.
Why couldn't we do that, Gene? It certainly allows the educational use.
Well, I think that goes to the question of whether the barn is accessory. Because I think clearly what we've got here is a provision in our bylaw that expressly prohibits the two buildings. And I continue to think that's simply in conflict with, it's not a regulation like setback or something else. It's contrary to Chapter 48, Section 3. That's what I think, anyway. That's my interpretation.
And it's contrary, why?
Because it's exactly the opposite. Our bylaw prohibits more than one non-residential building on a lot.
Right.
And Chapter 48, Section 3 says no zoning bylaw shall prohibit the use of structures or the expansion of existing structures, etc. And that's what we'll be doing.
Or the expansion of existing structures. We're not, first of all, I'm not talking about use at all. And how would my reading prohibit the expansion of existing structures?
Well, we prohibit the use of the proposed daycare center that they want to build.
Why? They can build it under my reading.
Because under your interpretation, that would be two non-residential buildings on a lot.
The
How does
alternative.
that prohibit the use of the new building they want to build for a childcare center? Remembering that the barn was never any part of their plan for the childcare center. That wasn't, as The barn had nothing to do with the childcare center, Gene. That was clear for the first 6 months of this proceeding. So how would that, any of this prohibit the use of the land or the structure that they want to build for a childcare center? I don't understand the reading that you're making of it.
Well,
There is a
don't
way
know what
around
else to say. If the barn is a permitted accessory use to the proposed brand new childcare center, then it can't be prohibited. If it is not an accessory use, then it can be prohibited.
And what do you say to the argument that it won't be accessory unless it's a customary use?
Well, then we can talk about that.
Okay, let's talk about that.
Right?
So-
You think that's
If
kind of
the
a bar?
ball is in my court, I'll mention that many properties in Needham have very large barns associated with them. I happened to be going for a walk on the foster land today and met the neighbor who invited me to go up and look at his house and his barn, which is a very big barn. And I happen to say, it's unusual to have such a big barn. And he said, oh, a lot of older homes have big barns like this. And okay, so that's history. But also, I think I mentioned this last time. Apparently, our building inspector just recently issued a building permit on Dwight Road for a new house and 2 great big accessory buildings.
So
I
these
mean, I
are,
assume,
but you're talking about a residential lot.
yeah, right.
Not
But
analogous.
I'm
Oh,
talking
I
about
see.
residential lots.
you're focusing on whether a separate building of the size of this barn would be considered a customary accessory for using, for storage, would be considered a customary accessible use to a daycare center.
We have, as far as I'm concerned, we have no evidence from Evans that demonstrates how a barn, let alone a building of this size, is customary to daycares either in the vicinity or elsewhere. We have no evidence to that. And I think that if that is the test of what's regarded as accessory, therefore it fails. And it cannot be seen as accessory regardless of its original intent or its subsequent intent, where they basically said much later in the proceeding, okay, we'll keep it, but we'll just keep it only for the purposes of the daycare. And they imagined a number of scenarios where it may be helpful for solar panels and storage. But based on that, I'll get to you in a second, Paul. Based on that, I'm not clear that this, in fact, is a customary use. Paul.
I'm not clear that it's a customary use either, because the barns that we're talking about are all accessory to residences. And so the argument would be that, okay, large structures like these barns are customary to residential uses, and it's not customary to daycare centers. But we have to get back to the question of, is it an unreasonable enforcement of the regulation of our bylaw? Is that an unreasonable regulation? So I want to raise the question, in order to get to that, why would we be requiring them to remove the barn? If the only reason that we have for requiring them to move the barn is that it's in violation of this bylaw, which the courts have said you can have valid bylaws, but in a 48 Section 3 situation, we can find it unreasonable for you to enforce that bylaw. Unless we have a good reason to enforce the bylaw, I think it's by definition unreasonable if we just want them to take it down because we want them to take it down.
Right.
Except,
So my argument would be, am I okay, Adam, or do you want
go
to?
ahead.
My argument would be a couple of things. First of all, that having both buildings would create too much bulk on the lot, which in fact is one of the things under 48 Section 3 that we can regulate. And having more space on this lot should relieve some of the pressure to have more on-site parking and traffic flow, which everybody seems to be concerned about.
A third point, if I may, Marty, is that I think in the Rogers Court, the preservation of the character of the neighborhood was regarded as a legitimate municipal concern, which brings up setback. And on that basis, if the building was set back to 200 and something feet, that was in line with the most analogous use in that area, which would be the temple, and where the attorney for the temple at the time intentionally said that they intentionally set that building back to preserve the character of the neighborhood, that I think that too holds.
Well, one more thing, because I need to add this in. One of the documents that I keep going back to is the Design Review Board of August, I think, 11.
Mm-hmm.
And it incorporates their comments from March and from May. Twice, the applicant was before the Design Review Board before we ever held a hearing on this. And twice, the Design Review Board basically said, well, what's with the barn? Why can't you set it back further? Why can't you make the barn part of the child care center? Look into these options. And they said that in March, they said it in May, and they said it in August, all 3 times. So it's not just because we want them to take it down, but because among other things, our Design Review Board has said to us, the aesthetics are not right.
It's not in keeping with the neighborhood.
Not in keeping with the neighborhood.
And Rogers has held that in and of itself is a legitimate municipal interest. The only alternative to that I see is that we require the setback and that they can include the barn. The barn has power. They can heat it and they can plumb it. They're going to be, I cannot imagine how they could not, it's a large building. They could still have part of that. In their current design of the new building, of the 10,000 square feet or so, they're going to have close to 1,600 square feet just as a play space. 1,600 square feet is like my house was 1,000 square feet. So that is a large play space. And they could still have, I'll get to you in a second, Paul.
Yep.
But with the size of that barn, they could still have that large play space and additional space for the rest of their facility. Go ahead, Paul.
Okay, so I came up with another alternative. And what Adam just proposed, which the Design Review Board, I think, may have proposed of combining the buildings. And my alternative, which would preserve the barn, doesn't address the concern that Marty raises, which is a legitimate concern, that having the 2 buildings is too much bulk in and of itself. Both buildings combined is too much bulk for the neighborhood. So that's a concern. That argument alone says we condition it that the barn comes down. It's too much bulk. I took a look at the plans and I took a ruler to the plans, the first thing I discovered was that it wasn't exactly drawn to scale, because the distances as shown on the plans didn't always match up with the ruler. But what I came up with was, you keep the barn, you move the building back almost to the barn. They have walkways on their plans, and all their walkways are 5 feet wide. Okay, so a 5-foot walkway. You have a 5-foot walkway between the barn and the back of the building. You set the building back. You don't even have to change the design. You don't even have to reconfigure the building. You just push it back so that it's roughly 5 feet. Okay, so it's 7 feet. I'll give them that. From the barn. So they have access to the barn for storage, which is what they say they want it for. They have access to the barn as a complimentary play area for the kids. And what I came up with, because it wasn't exact, I couldn't come up with an exact number, was that now the Central Avenue side of the building, which is kind of a side, it's not the front, because I think the front is facing Temple Aliyah. The Central Avenue side of the building would be approximately 130 feet back. And Adam is still pushing for 200 feet back. Jean has said that she's okay with the 64 feet that they've already proposed. I think I'd be satisfied with 130 feet back. I don't like 64 feet. I don't think it fits into the neighborhood at 64 feet back. But I think it might be okay at 130 feet back, but that's far enough back that it preserves the character of the neighborhood. Doesn't solve the bulk question, though. We now have two large buildings. It's a big lot. It's a lot of land there.
And it also doesn't satisfy the question about 2 non-residential structures on 1 residential lot.
Well, but then we get to the question of whether it is an unreasonable regulation for us to enforce that bylaw provision. Where, is it really necessary to enforce that bylaw provision here in order to preserve the character of the neighborhood, which is really what we're talking about here. Both the setback requirement and the bulk of the buildings, that all comes under the preservation of the neighborhood, which is a legitimate municipal purpose.
May I ask you about your proposal, Paul?
Yeah.
Where would the loading area, the handicap parking spaces, and I guess there's another 2 parking spaces that are in that area you're speaking of, that the building?
I think they have to reconfigure the whole parking, and they've got so much land there, Gene. They've got land behind the barn. They've got land on the sides of the barn. They've got land on the sides of the building. And it seems to me that it shouldn't be all that expensive to have their architect, their surveying engineer reconfiguring the parking in the drop-off area and the loading dock area, where there's so much land here. It's not like we're dealing with a 10,000 square foot parcel of land. They've got plenty of room.
One thing I like about the current design is that the drop off and so forth is set back from the front. You do see the building, and changes were made to make it more residential in appearance. The long profile of the building faces the temple, so the profile that faces the street is not that long. And
that's where the
as I
front of the building is. I
recall,
think that's where the front door is facing the temple.
Yes.
well, that's where the children are being dropped off and so forth.
I
But
think
I'm
that's the
talking,
front door of the building.
but what I'm talking about is the facade that faces um, Central Avenue is, is somewhat residential in appearance, the way it was redesigned. And the landscaping that is proposed for that area seemed pleasing. What I wouldn't want is a relocation of the drop-off to be or any parking whatsoever to be in front of the building. I think more than anything, that would detract from the residential use look of the neighborhood.
And they've got plenty of room on the sides and in the back to reconfigure parking.
Although the
Then it, oh,
But the temple has parking in the front, and it's had been reasonably screened. I'm not opposed to having, supplementary parking of a number of spots, in the front, particularly if it's screened. I mean, remember, they also have a 6-foot elevation change, I think, on one of the sides of the building. They go from 205 feet to 199 feet on the southern edge. And at the northern edge, their elevation is 206 feet.
for example, the current parking area is a significant distance away from the property of Greg Dara and Nicole O'Connor, which I imagine they're fronting on
Country Way.
Country Way. But to create a new drop-off area and to create new parking could mean that the parking would necessarily have to be closer to those property owners. I don't know. I'm a little concerned. I'm concerned about relocating that parking area. And I find it hard to know how we can exactly say what we want in a condition and then have the site plan be done to exactly meet our requirements
Gene,
at this. Yes,
take a look at the plan.
I am looking at the plan right now.
Take a look at the parking lot that's behind the barn. You see existing
Yes.
buildings remain, and you've got the parking lot that's behind the barn.
19
Yes.
spaces.
And then you've got all that land behind that parking lot. All you need to do is expand the parking area further back on the lot, create more spaces. You're going to have a huge parking lot behind it, but nobody's going to see all that parking except, the Darishes are already looking on that parking lot. And the O'Connors, yeah, they're going to be looking at a parking lot, but, let them screen it. They've got plenty of room to move the parking that's on the side or the parking that's currently in front of the barn. Those 6 spaces that are beside the barn don't need to be moved. You're only talking about those few spaces and the loading area that's between the barn and the existing building and moving that behind the barn where there's plenty of land.
Mm-hmm.
And we don't have
Yeah,
a tree bylaw right now.
But the
They're free to
loading-
take out whatever
the
trees
loading-
they need to.
The loading area is a very active area, a very important area to make sure that works properly. I find it hard to imagine where else it could go. I guess when you moved the building back, the loading area would have to be behind the barn and have some kind of big circle in behind the barn, and then
We don't
additional
have
parking
Gene,
farther back.
we don't have to micromanage that.
We don't?
No, in the sense that we can set out certain conditions or requirement of where we want the loading and other basic, but they can design and they can come back to us. But none of this addresses Marty's question that's kicked this thing off. This solution has the benefit of probably being a little bit more, it may be a little easier through an appeal, but it's not necessarily the right approach. If legally, what we're saying is that you, notwithstanding the Dover Amendment, you cannot have more than 2 non-residential uses on a residential lot, and where the bulk itself is exceedingly massive, and that the residential character is not preserved. It's a reasonable legal argument to just require the removal of the barn, period. And to set this thing back, I would propose I don't think if we remove the barn, I don't think it makes sense to set the building back to anything other than the most analogous use, which would be Temple Aliyah. And that's why I think we have to resolve Marty's question first.
The barn, I will just say, to me, it's beyond clear that the bulk problem is all with the barn if the barn stays. And it's been made clear to us really from the beginning that the barn has nothing to do with the child care center. To say that, well, yeah, maybe they'll use it for storage, I mean, that's obviously an afterthought. And they're doing it because they feel like they have to. But it really has nothing to do with the child care center.
And that also presumes, Marty, that it's a bona fide accessory use.
That's correct.
Jean, would you regard the barn as a bona fide accessory use?
I mean,
Yes, I can see that it's an accessory use, and that barns in themselves are traditional accessory uses.
But hold
And
on, Jean.
that,
What, Jean?
to say that you're going to preserve an existing barn in order to use it for storage rather than making the building larger. I do have a question. It may seem beside the point. I'm not sure if it's time to bring it up, but I noted in one of the letters that came to us, because I was reading them over again, that we got before our last hearing. The question was, what is the actual size of the building if you include the barn? And if the parking should be based on size of the building, haven't we miscalculated the amount of parking that's required? So I am concerned about that aspect of preserving the barn. In what the question I wanted to ask, and I didn't have time to research it myself, was when you calculate the amount of, I know that we don't have this particular use in our table, uses that require X parking, daycare centers, that is. So we're saying, we're using the part of our bylaw that has us consider similar uses and so forth, and we've come up with a formula for it. But it seems when we came up with the parking, it wasn't clear that the barn was going to be used just as an accessory. So I'm wondering whether
it's still not clear.
Whether if the barn is to be used as part of the building, have we correctly calculated the amount of parking? For example, if the building were enlarged to include that amount of storage space, would we have calculated a larger amount of parking needed? Or when we're calculating amount of parking, do we discount storage space? Is that typical? And is that what we would do?
parking I regard as a separate point. I want to go back to this and just focus on, we're off track here.
Wait a minute.
Okay,
Ho-
sorry.
Hold on. I have to stop you, Adam, because Gene said something to us just now that I find to be really interesting, but I think exactly backwards. Maybe I'm wrong. She said that without the barn, maybe the childcare center would need to be a bigger building to add storage. I think it's just the opposite. I think the childcare center was designed so as not to use any of the barn for storage. That was made clear to us. So my question then is, well, if the building doesn't have to be enlarged, if it's now going to use part of the barn for storage, the childcare center can shrink. I think that's the way to look at it, because now it has all this storage available to it. So it should be a smaller building.
That's very interesting.
Well, I was only thinking of, should we really be considering that they need more parking? And if so,
Gene,
we have to think about where that would go. That's all.
Paul?
I understand you're raising the size of the buildings to determine parking because that's what our bylaws do. But what our bylaws also do, and what we do all the time, is we give parking waivers. People come to us all the time and say, okay, your parking regulations say we have to have X number of spaces. And you're saying, well, you know, if there's more floor space, they need to have more parking spaces. But we really don't need all that parking. We're only going to have X number of employees and Y number of visitors coming here. And so we don't need that. And so we ask you for a parking waiver. The fact that you've got a barn that's being used for storage doesn't increase the need for parking. The need for parking is based on the fact that you've got a certain number of cars that are going to be parked there for people who are going to be using the building. And, you know, if 30 spaces is adequate now with the plan that they have, with the barn being totally used for storage, then 30 spaces is adequate if they move the building back and include the barn as part of the
But
building.
I don't understand about parking, notwithstanding the size issue. And again, this throws us off topic a little bit. But to complete the comment on parking, the ITE standard at the 85th percentile would be 37 or 38 spaces. And I've never really understood how, even the peer review had accepted the 30 spaces.
Because we weren't using that standard. Our town hasn't been using that standard for childcare centers.
The town was using a standard that the town did not have a standard. And at the time we first started looking at childcare centers, it was not actually, I think in the ITA journal. And there was a memorandum that was put out, which was a recommendation on how to calculate the parking demand for childcare facilities. And there were two equations that were in that manual that recommended that you could either calculate it on a square footage basis if you did not know what the projected enrollment was. And then there was another formula that was based upon knowing what the enrollment was and calculating the parking that way. And so those particular equations have been applied universally across all of Needham's childcare facilities for at least the last 15 years.
Okay, so
And it
that
was
would be
not-
the applied standard. That's helpful. So let's go back to the central issue here, which I think is the barn in and of itself legitimate? Gene, let me ask you this. Are you satisfied, based on the information that Evans has provided to us on behalf of the applicant, that a barn of this size is customarily used as a daycare center?
as an accessory building to a daycare center.
I guess I am satisfied that I believe we were presented with information regarding the storage needs.
We
And,
haven't been. We
I
haven't
thought
been. Like
we were.
Marty said,
I
that was
thought
an.
that
that was an
the
afterthought.
anticipated operator had presented us with some information on that at one of our hearings. I seem to recall that.
But like
She
like
talked
Marty
about
said, that was
the
an afterthought.
storage that she has at other facilities in town and various outbuildings and of those facilities, and that this would be similar, I believe. I'm remembering that correctly.
So what she has at the Baptist church, as I recall her testimony, is that she has a storage shed and she has a garage.
Mhm.
So we didn't get square footage. Let's assume 600 square feet for a garage, and a storage shed, another 100, 150 feet, call it 200 feet. So she's got 800 feet of storage, as opposed to this barn, which is a 2,500 square foot floor plan and as Adam points out, 4,500 square feet of space. If she only needs 800 square feet, if she only needs 1,000 feet, you know, they can buy sheds.
But no matter what she alone now uses, how does that make it customary? That doesn't tell us anything about what other childcare centers do.
Exactly my point. So Gene, let me ask you this, Gene. What other daycare centers are you familiar with, not the existing operation, that customarily use a separate second building this size?
Well, it's got to be in the record. It's got, we have to have evidence of whatever it is in the record. There
Well,
isn't
the
any.
only evidence, Marty, the only evidence we have is from Holly, which calls out 20 different childcare facilities in the vicinity, none of which have a structure, let alone a structure this size. That's a separate structure on a separate non-residential use in a residential district.
So what I'm asking Gene is there anything in the record to say otherwise?
All I recall is the testimony of the intended operator, which I think Paul remembered more precisely than I did.
Okay.
And that was only as an afterthought after Evan's admission that it was intended to be used for the owner's personal use for a boat and a car. Which is why Marty, I think, said it was an afterthought at best.
Well, I must admit, I'm coming from the point of view that the front setback is far enough back. And the arrangement for the circular driveway to pick up and drop off children is a good arrangement. And so therefore, if I realize that my point of view is not one that is shared by other members of the board, but therefore I don't see a big reason for tearing the barn down. I mean, Marty says just makes the whole property, as far as the structures on it, would be too much bulk on the property. But also, it's been pointed out, it's a very large parcel. The barn has been there for a long time.
But those considerations, Gene, the age, how long it's been there and the size of the parcel, don't enter into that use category at all. It's irrelevant to the use category. And so I'm not even saying, don't get me wrong, because I haven't decided this yet. I might even be able to live with that setback of 64 feet myself. But as part of the conditions, because of the bulk problem and the aesthetic problem, I would still make it a condition that the barn has to come down.
I see. Okay. I appreciate that understanding, Marty. Thank you. Yeah.
Paul,
I'm staring at the plans. And that building at 64 feet to me is totally out of place in this neighborhood. I'm looking at it and I'm comparing it to the barn. You know, the barn is like 20 or 20, not even 25% of the size of that building. That's a big building. And it's 64 feet from Central Avenue. That is a lot of bulk for the neighborhood that we're in, where all the houses are set back, except for the Heidemann house. All the houses are set back at least 100 feet with a lot of landscaping. That is a huge building. I want to see that building set back. I think that I could be satisfied, not totally happy, but satisfied if we allowed them to keep the barn and we set it back, like I said, so that it was 130 feet back. I understand Adam's position that it should be further back than that, which means they have to remove the barn.
or include the barn, by the way. They can include the barn.
Well, Adam, even if they include the barn, if you move that building back to the barn, I mean, I'm only talking 5 feet between the building and the barn if they don't connect it. So you're still talking about it's being set back only 130, being set back 135, maybe 140 feet if they push it back and then attach it to the barn. You're not going back 200 feet if you do that. So, you know, the reason for pushing it back is that it doesn't fit into the neighborhood. It's preserving the character of the neighborhood, which the courts have said is legitimate municipal purpose. I don't think it's unreasonable to have them move it back, and whether, no matter how much it gets moved back, Gene, it affects the parking. You move it back 15 feet and you eliminate, and they got to reconfigure the parking.
Understand.
Because there's a parking lot right behind it.
And I think when you talk about preserving the neighborhood, are you referring to the Tufts case?
I don't remember whether it was Tufts or Rogers. I don't remember which case it was, but well, the Tufts case does include preserving the character of the neighborhood in the list of municipal purposes.
But what the city of Medford was trying to do was enforce the dimensional requirements of its bylaw. And here, where we would be setting a requirement that the building be pushed back when we have no such requirement in our bylaw. I find it hard to believe that such a requirement would be upheld by a court.
But preserving the character of the neighborhood is in our site plan, major site plan, special permit criteria.
I
It's
understand.
there. It's in the bylaw. And again, I'm going to read from the Tufts case. And it's a general statement. It's not specifically applied to what Tough specifically wanted to build. This is the SJC giving the general language. Local zoning requirements adopted under the proviso of the Dover Amendment, which serve legitimate municipal purposes, sought to be achieved by local zoning, such as promoting public health or safety. This gets to the traffic issue. And with all the traffic that we've discussed, all the traffic issues that we discussed, if you push this building back and have a longer driveway, it is going to make some alleviation of the traffic issues that we've been talking about. To have that much more, and another 65 feet of driveway until you get to the building is going to alleviate some of the traffic. So let me go back. Other purposes to be achieved by local zoning, which serve legitimate municipal purposes sought to be achieved by local zoning, such as promoting public health or safety, preserving the character of an adjacent neighborhood, or one of the other purposes sought to be achieved by local zoning as enunciated in, they cite a 1975 statute, may be permissibly enforced consistent with the Dover Amendment against an educational use. So, and I'm convinced that pushing that building back better preserves the character of the neighborhood. Whether you push it back and allow the barn to remain, or you push it back, say that they have to raise the barn and push it all the way back to 200 feet.
What about keeping the barn, but shrinking the daycare center and pushing it back? Because now they have all this storage in the barn. They don't need that space in the main building.
They don't have it now, storage in the main building now, which I don't understand. How could you design a building specifically on the requirements and the needs of the operator and not include storage if storage was that significant?
I think
Clearly it wasn't that significant.
Well, or there is storage included, they just don't show it on the plans.
So I wondered about that, Marty, and apparently it's a slab. Like I thought maybe there was a basement of a similar size that they could use for storage, but apparently it's a slab basement. Nevertheless,
I think having them reduce the size of that building might be an unreasonable regulation, Marty. And I think there was something in one or two of the cases that talked about that.
Well, there was one case where there was a 2,500 square foot maximum. The existing building was 3,100 square feet.
correct.
And the court found that to enforce the 2,500 square feet requirement under those facts and circumstances was not going to fly.
And yet they still upheld the general concept that it's legitimate for the town to have a 2,500
Yes,
setback,
you
a
did.
2,500 square foot
Size limitation.
FAR.
Right.
That's right. So would it be helpful to have town council, who I understand is accessible tonight, to chat through some of these questions? Not at this hour.
I didn't realize he was here.
It's not that he's here, but we could, he could be available to jump in. But we don't necessarily need to do that if Marty, you seem to have some thoughts.
Well, I'm not sure what Chris could do for us right now. I'm not sure where we are on this.
Chris Heath is listed among the attendees.
Is he? Okay.
Yeah.
I'm not against it. I'm just not sure it's going to be helpful to us. I think we have a pretty good understanding of the law.
I think we do.
But question is, what are the options that we, as a group, want to follow? And I'm not sure that we have a consensus of any kind yet.
Before we figure out that consensus, I'm not saying that I'll include this person, but I do see that among the attendees, we have a hand up from a Louise Note 10. But I don't really know who that is, and we're not in a public hearing scenario, so, and we're not currently taking additional testimony, so I don't intend to recognize that person at this time. So shall we seek consensus on this, on the issue of whether or not the barn itself is a legally permissible structure? Or do you want to resolve setback?
When you say legally permissible, you mean legally permissible to stay if a separate childcare center building is built? Is that what you mean?
Correct, in this circumstance. Because one of the things, Marty, that I find interesting is that on the other hand, you're also it seems as though you may, I might be putting words in your mouth, so forgive me, but you might be agreeable that if the main building was shrunk down considerably, they could potentially keep the barn. Was that right? Did I understand that correctly?
You understood that as a possibility. I've decided nothing, but as a possibility, I mean, it seems clear to me that if we're going to get a consensus decision here, we're all going to have to bite the bullet on some things. I don't think any of us is going to be fully satisfied. When I said to Jean that, I might even be willing to say 64 feet is enough on the setback, it's not because that's my preference, but it's because to reach a decision here, maybe I'll have to. I don't know. That's where I am. I'm up in the air on a lot of this stuff right now.
Gene, before I come to you, Paul had his hands up, so I'm going to recognize Paul first.
Yeah, I'm looking at the chart that was prepared by Chris Heap, and I'm looking at Primrose School, Primrose 2. And under ruling, he's got the land court ruled that the ZBA could not limit the number of students that could be enrolled at the facility. And I think that this building is built, I know that they're saying that they're only going to have under 100 students. And it seems to be big enough to have about 125 students.
Well, specifically, Paul, they've actually said that they will have no more than 115.
Right. But my point is that if you reduce the size of this building, you're going to be reducing the number of students that they can have, which goes against what, and
in Primrose.
I haven't read Primrose 2 in a long time, but according to Chris Heap, Primrose 2 says the land court ruled that the ZBA could not limit the number of students that could be enrolled at the facility. And by it seems to me that by chopping off, 2,500 square feet from this building, you're going to be limiting the number of students.
Adam, that
Yes.
leads to a question that I have. I've been assuming all along that we're going to be able to make it a condition of our decision that there shall not be more than so many students. Because they told us they're going to have 115. Can we do that? Or
Yes.
does Primrose 2 say you can't do that?
No, where the applicant has offered a maximum and we agree to that, that's an enforceable condition.
Are you sure under Primrose 2?
Yes.
I
Hey,
don't
hold on,
think
Paul, hold on. So I verified that with Chris Heap. Again, I'm happy to have him come in and speak to it. The caveat, Marty, is that in the event this building is sold and a subsequent owner or operator seeks to increase the number of students based on that operation, I'm not sure that we could deny that subsequent amendment.
Well, this is a really important item. That upsets my entire expectation of putting that kind of condition in here. I think it's very important that we be able to say the condition stays, period. Now, they can always, you can always come in and ask us to change it, but we don't have to. But maybe Primrose 2 is saying we might have to.
So one second, Paul, where this is an agreement and something that they on their own have offered, it's an enforceable condition for the duration, except where if a subsequent developer or subsequent owner seeks to increase it by an amendment, we could deny it and then have, and then it may be challenged in a court if we deny it based on Primrose. But I think the best thing to do to satisfy you is to probably bring Chris in if he's available. Paul?
I don't recall any of the cases being a case that's brought because an amendment to an existing list of conditions has been denied. They've all been initial petitions. It seems to me that if we set out the conditions that includes 115 students maximum, and it's not appealed, and we go down the road 5-10 years, and it's sold 20 years to a new childcare center who says, I can fit another 10 or 15 students in there and I want to get rid of that. I think our conditions have been accepted by the original developer, and the subsequent buyer is stuck with it. I don't think the courts would say that a condition that was not challenged as unreasonable at the time that it was set can be reopened many years down the road.
I agree with you, Paul, very much on that
I
point.
totally want to agree with you. I mean, that's why I'm saying this is really important to me, because that was my expectation, 100%.
Yeah.
But
So
I'd love to hear Chris Heap tell me that we're all right.
Alex, can you bring Chris in, please?
I don't disagree with Eugene or
thing.
Hi, Chris.
Everybody.
Thank you very much for being available tonight.
Of course.
Have you been following
for us, Chris?
Have you been following the last period of our deliberation here?
I have, and I'm comfortable that if you include that student limit as a condition in your approval, that's likely going to be enforceable forever. When I discussed it previously with Adam, I did, include the, I think, slight caveat that if somebody asks to amend that condition 20 years from now, and the planning board denies that requested amendment, there's a chance that they could file an appeal. I don't like the new owner's chances in that appeal, but that is something that could happen. But so no, if you include a condition and 20 days go by without appeal, and that decision and that condition become final, I think that's as comfortable as the board can ever be that that's going to be enforceable going forward.
So you don't think that it'll be a survivable appeal? They always have the legal opportunity to do it, but you don't think that it's a likely outcome?
I don't think it's likely that they would win that appeal.
As I tell my clients, anybody can start a lawsuit.
I understand that, but the question
is, well, what are your chances of winning?
Right.
I understand. I guess what worries me is when Chris says on Primrose 2 ruling that ZBA can't limit the number of students that could be enrolled at a facility. Are you saying except where it's been proposed by the applicant?
That was a contested condition that the applicant saw fit to appeal to land court. So there was no agreement between the applicant and the zoning board of appeals in that case. Where the applicant is volunteering to limit the occupancy to a certain number, there's no reason the board can't capture that in a condition that would be enforceable going forward.
That's what I thought. Thank you very much. Maybe calm me down here. I was quite a lot concerned about that one.
No, I think that should work fine.
Okay.
Dean?
And I'd like to ask Attorney Heap for a clarification on the case of trustees of Trust College versus Medford. I believe that is the case that Paul Alpert was reading from just earlier at this meeting. Is that right, Paul? It was that Tufts case. Yes. But your summary of the Tufts case, and that your summary in general, very, very helpful. And it said that there were parking, loading, and setback requirements of the Medford zoning ordinance that the city wanted to apply, that were objected to. So it wasn't something that just came out of a site plan approval where they thought, well, we want larger setbacks or more parking. It was that they wanted compliance with the Medford ordinance. Is that correct?
That is correct. And I think that's an important point. And I think that is a point that is true of not just Tufts, but I think just about all, if not all, of the other cases that are included in the outline that I sent to you guys. All of these cases tend to deal with objective dimensional requirements that are contained in the zoning bylaw or the zoning ordinance. So in other words.
And whether you can apply them or not.
Correct.
Right. Okay, thank you for that clarification.
Well, while we have Chris, let me just ask you, do you view the requirement that you can't have two non-residential buildings on a residential lot to be one of the requirements that we can enforce?
I think that the barn is likely entitled to protection of the Dover Amendment to the extent it's being used for childcare facility purposes. And I'm hearing, I did not hear all of the evidence that the board members did over the course of the public hearing. And I think there's some conflicting evidence and maybe opinions as to whether that barn is going to be used for childcare purposes. If it is, then, I think it would be difficult for the board to tell the applicant to tear the barn down. If it's not going to be used for childcare, then I guess I'm struggling a little bit with how the barn is protected exactly, other than maybe as an accessory to the childcare use, which might be allowed not protected by the Dover Amendment, but allowed under the terms of the town zoning bylaw, given the provision that Paul cited on page 33.
Except that the question has come up that even if it were, and the final testimony we had from Evans was that where previously the owner intended to use it for personal purposes, they subsequently, on learning that it can't be anything other than an accessory use, then therefore it will be an accessory use, so they can keep the barn. And but the question has come up as to what is that standard of accessory, because it has not. We have no evidence from the applicant to demonstrate that a building of this size is customarily used as a second building for a daycare center. We have no evidence to that. And that seems to be one of the tests in our own definition. The other question that has come up is the question of bulk. And that in the event that a building of that mass combined with the 10,000 square foot mass of the other building is too much bulk and way, for the site. I mean, if you look at any other of the footprints on the buildings around here, outside of Temple Aliyah, you don't have one building 10,000 square feet and another building that's 4,000 square feet. I don't see anything like that around here. I see some separate buildings, but those second separate buildings are not remotely in the same proportional size.
You should see the building that Gene referred to where they're building the new barn.
I did.
By the way,
I did.
It wasn't so long ago that was a ZBA application that we reviewed.
And approved.
I recused myself because I'm an abutter to an abutter.
Huh.
And my recollection is that they didn't go to the ZBA and said they wanted to build a barn. They went to the ZBA and said they wanted to build a 4-car garage.
Yeah, I guess that's what they call it. Yeah, it's just
So-
very large. That's
But they're separate structures. Gene, you were there. Like me, you probably saw there are separate structures.
two separate structures in addition to the house.
Yeah, it's a lot of bulk on that lot.
Yeah, it
Yeah, but
is.
it's also set all the way at the very back of the very back of the lot. You can't even really see from the lot, from the front, that the garage. You can see the barn, but at that setback where that barn is, it's not distorted from the size of the house, which itself is a smaller house. But nevertheless, we're off topic. Let's stay on topic here.
No,
So
but we're talking bulk. We're talking bulk in terms of the neighborhood. And that barn is, I consider that the neighborhood. It's pretty much the same block. It's around the corner. And everything that you're talking about, Adam, it's all residential. We don't have 10,000 square foot houses. Most we've had is what, 6,000 or 7,000 square foot houses, and those are huge. But this is an exempt use. So compared to that extent, it's.
But how do, I mean, we say it's an exempt use because an accessory structure is protected. But what we find is a distinction between an existing building and a new construction.
No, I'm talking about the new construction. The new construction. Yeah.
But unfortunately, the existing construction, it was created perhaps as a fiction after the fact to be accessory. Like Marty said at the outset, for 6 months into the hearing process, that barn was regarded as a personal property of the owner and not the operator.
I agree. I can't disagree. And we have to reach consensus because any decision we make requires 4 votes. Receipt is still here, requires 4 votes, right, Chris?
I believe it requires 4 votes, correct?
Yeah. So we need to reach consensus.
Right. So go ahead, Chris.
The only comment I would add is that if there was competing testimony over the course of a long public hearing as to the use of the barn at the beginning of the hearing and at the conclusion of the hearing, but the last testimony that the board took was that it was going to be used by the childcare facility for a particular purpose, I think you can take that fact as the current state of the facts, and you could always capture that in a condition in an approval. So to the extent you're worried that the barn is going to be used by someone else, other than the childcare facility, you could always preclude that from happening in the form of a condition.
So there are a couple of other ways, I guess, to address this. One is by the setback, where the preservation of the neighborhood, of the character of the neighborhood has by Rogers been regarded as a legitimate municipal purpose, and that setback is wholly acceptable under the Dover Amendment as one of the criteria. We could potentially be silent as to what they want to do with the barn. They have the option of including the barn as part of the structure. But we could set the building back in keeping with the temple because it's the most analogous use. And if they want to keep the barn, they can. I don't see a problem with that.
Well, if I speak, if the issue is that a barn of that size, even if it's used entirely for storage, or just left vacant to the extent it's not used for storage, by the daycare center, is unnecessary bulk. And we back up that argument by saying, originally, if the daycare center was going to be built and they weren't even going to use this barn. So the idea that they really, really need to use it was just sort of made up. If we go in that direction and say, because the entire project is too bulky, the barn should be demolished, I could go along with that. What I cannot go along with is that necessity to move the building back. Almost twice the required frontage, the required setback for this zone. I fear that that requirement would not held up in court. It's not like suppose they propose 20 feet and our requirement is 35 feet. Well, of course, we can require the 35 feet and it would hold up in court because it's protective of the neighborhood. But to say the requirement is 35 feet, they're going to 64 feet and we want it to be 200 feet or even 130 feet, I fear that it will not hold up. And I also fear, if this is appealed because of a condition that the applicant does not, challenges, it's going to be very costly for the town because it's between us and the developer. If we go forward with something that the neighbors think we shouldn't have decided that, and they appeal it, it'll be between the developer and the abutters and their attorneys. I don't know if you agree, Chris. I know in my experience as town council, we generally stayed out of the fight. Let them fight. Why should we incur any expense? So I'm trying to protect the town from getting involved in all that litigation that I fear we will not win. So I'd go along with tearing down the barn if we legitimately think that is not a legitimate accessory building and it is too bulky. But I don't go along with the setting back the building. So if the reason for removing the barn is to set back the building, then as far as I'm concerned, the whole thing is illegitimate.
Paul?
I'm going to disagree with Jean because I'm staring at the plans here as we're talking. And to me, if this building is staying at 64 feet, I don't see where it's reasonable for us to force them to remove the barn because it's set back considerably from that building. They've got the parking. I don't think we have a legitimate reason. I think it's unreasonable for us, if this building isn't moved back, I don't think it's, I would say that it's unreasonable to force them to remove that barn simply because we don't want it there. I'm staring at this plan, and to me, the major bulk here is the new building. The barn is dwarfed by that new building. And to me, the only reason to force the removal of the barn is because we want the building set back and the barn is in the way. And I've said this before. I've probably said it in a public hearing record. I'm a lawyer. I'm a practicing lawyer. I don't fear litigation. I have never had a problem with the town spending money for legitimate legal services. And I'm not going to walk away from something because I'm afraid of litigation. You know, litigation is there because there's a dispute. And I think this would be, you know, if somebody wants to appeal, it will be a legitimate dispute. We're not being frivolous. We have, as I read from the Tufts case, that preserving the character of the neighborhood is a legitimate municipal purpose. We have the design review board agreeing in writing after 3 different hearings that they don't see this building as necessarily fitting in with the neighborhood, with the character of the neighborhood. And so they say, why don't you move it back? That's in the design review board. Move it back. And the developer here, crickets.
Or include it. They also gave that as another option too.
Yeah. So, you know, yes, they could appeal and they could win. I think it's money well spent, even if the developer wins. Because I think we have a legitimate reason to say 35 feet, 64 feet doesn't fit into the character of the neighborhood. We have a bylaw that says that on site plan review, we can consider the character of the neighborhood and preserve the character of the neighborhood. That's what we're doing, preserving the character.
Upheld in Rogers.
Pushing this building back.
Upheld by the Rogers court. Chris?
Yes, and I'm willing to somewhat compromise by saying leave the barn, put a 5-foot walkway between the barn and the building, push the building back so that it's 5 feet from the barn. We'll have frontage at about 130 feet. I wouldn't be totally happy with that. I'd like to see it pushed back farther, but I could probably live with that a lot better than the 64 feet that it is now.
Chris?
I just want to jump in and just add one comment that I want to make sure all the board members understand, which is that the Rogers case does talk about protecting the character of the neighborhood being an important local interest that you can bring to bear when you're reviewing a Dover Amendment use. But what we're talking about doing here is a little bit different than what was under consideration in Rogers, and I think a little bit different than what we've seen in other cases that I've cited to you. In that, in Rogers, the proposed daycare facility violated the applicable dimensional requirement, which was the 2,500 square foot floor area cap. What they were proposing there was 3,200 square feet. 3,200 square feet. So they wanted to go above and beyond what was allowed under the bylaw. In Tufts, for example, they wanted to build, the setback was 50 feet from the street, and Tufts wanted to build closer than 50 feet to the street. So we're talking about applying a site plan review criteria here in terms of protecting the character of the neighborhood and looking to push the building further back than the baseline setback requirement, but which I'm not suggesting the board can't do, but is something that you have not seen in the case law previously. So that is
An important distinction.
the requirement that we're applying here from our zoning bylaw is of a different character than the dimensional requirements that you typically see discussed in the Dover Amendment case law relative to childcare facilities.
So we'd be making new law, which as a lawyer, I'd say is always exciting.
Marty?
Yeah, I appreciate what Chris is saying, but I sort of feel like Paul, so what? So what? I mean, that's what makes a good case. Yeah,
I would like to discuss process for a minute. I'm wondering whether, as we go through the list of conditions that we want to apply, if we might be content to do something like have a majority vote rule here among us, so that our vote on the conditions doesn't necessarily need to be unanimous. Then when we get to the final vote to grant the permit, which of course we won't be doing tonight because it'll be drafted and we'll vote on that at our subsequent meeting, then that's when the supermajority rule applies, just as a way of moving forward in this process.
So that way, if we have less than a majority on each, in other words, we have less than 4 votes on each of the conditions and the relief that we're seeking, as we lead up to the decision, how do you resolve the decision?
Basically, the minority concedes to the majority, I believe is what I'm hearing Gene say.
That's exactly right.
So if we don't in the first step have consensus, Gene, on the barn and the setback and other conditions, you're prepared to change your vote and grant that relief that you formerly opposed at the time of a vote on the decision?
Well, that's right, because otherwise, what is the outcome? The outcome is we simply deny the permit, which we can't do anyway. So it's almost like you just have to do it, you know?
And I'll state for the record that if I'm outvoted 3-1 on any of these conditions, I'll change my vote to make it 4-0
after trying to change our minds.
after trying to change your mind. Yeah.
I think we all will. I expect. I would only
Too.
I would only amend Gene's comment to say one thing. I think we're sort of talking about 2 tracks here at this point. One, keep the setback the way it is, as Gene argues for, and impose conditions, and we'll lay out the conditions. Among those may be the barn's going to go. A separate track would be Paul's idea of moving the building back and keep the barn with additional conditions. So we could set up sort of 2 different tracks with all various conditions that would apply to each, and then sort of vote A or B. We could do that too.
My preference is to be declarative, be decisive, and get on with it. Let's make some decisions here. If we're not ready to make a decision on some of these bigger things, then let's talk about some of the smaller things. My preference is to 2 tracks. I think becomes confusing. There are different conditions imposed. I don't know if the parking standard changes. I don't know if traffic mitigation changes, landscaping changes, other conditions like how we handle if there are other school events and there's additional parking demands. My preference is to resolve the bigger issues and then move forward and decide everything else.
If we can, that's my preference too, but my suspicion is we may not be able to do that, but we can try.
So Marty,
Mr.
yes.
Chair, could I just plead for a 5-minute break?
Yes,
Thank you.
We'll reconvene at 9:15, folks.
Thank you.
Thank you. So what's everyone's process, everyone's desire to go on a multi-track process here?
Well, why don't we see if we can come to an agreement on the big issue? And then maybe we won't have to do that.
So let's start with the concept that, is the barn a lawful, are we allowed to have two non-residential structures on a residential lot?
Well, as you can imagine, my answer to that is, in this case, under these circumstances, the answer is no.
I agree.
And my answer is that if the barn is necessary to the operation of the daycare center, then it is legitimate accessory and we must allow it. But I question whether that is the case under the circumstances of this application. So I'm inclined to say that the barn is not a legitimate accessory structure for the daycare center that's necessary to its operation. And that's my answer. It's, I guess, similar to Marty's.
Paul?
I'm not as adamant as Marty and Adam to say that it's definitely not allowed. I think that to take that position could be seen as unreasonable depending on the circumstances. I agree with Jean that if the barn is a permissible accessory use, then it's allowed, and I think that it trumps the two structures. I think there's a conflict there, and I'm in favor of accessory, but I also agree with Jean that I don't think it's a necessary accessory use. They made it clear that that wasn't the original intent. They were there for a long time. They only made it a storage facility because it became clear that they couldn't have two uses on the property, that wouldn't hold. And so they came in with that. And if you tore down the barn, she'd lose 2,500 or 4,500 square feet of storage. She doesn't need that much storage. They can buy sheds for not a lot of money to put on that property for whatever storage she needs. They could easily get 1,000 square feet of storage by having a couple or three sheds to replace the barn. I think that if we decide to set back the building, the barn can be removed. If we don't decide to set back the building, I think it would be unreasonable to say, even with the building in its current position at 64 feet, you have to remove the barn.
Now,
I just add that the reason, everybody was explaining, I was just giving you my answer. So my explanation also includes the fact that I don't believe we have any evidence in the record that a barn this size is in any way customary to a daycare use.
I agree.
Therefore, it can't be an accessory use.
now to the concept of two uses on a lot, Paul, if they have a shed that they build that's 1,000 square feet as storage, that's still two non-residential uses on a lot.
No, it's an accessory use to the child care center. It's a more customary use. I don't recall seeing 1,000 square foot shed. Yeah, they would have to build one. And I don't think she needs 1,000 square feet, but if they had a detached 2-car garage that they used for storage, but that size, that's a customary accessory use.
Well, we don't have any evidence of that either. We don't have any evidence at all of what's customary use for a second outbuilding.
I think a storage building, a reasonably sized storage building is a permissible accessory use.
Marty,
Such as an accessory use, such as a garage, a tool shed, a cabana, a greenhouse, such as.
Gene, I see your.
A reasonably sized storage facility is a customary use.
So, Gene, I see you nodding. Marty, do you concur?
Concur with what Paul just said?
Yes.
As an accessory building, as a second building.
Yes, I could buy that as an accessory building if it's of a size and type that's customary.
So now, what Evans has presented to us with a cost of more than $500,000 is to rebuild a building of that size. None of us are suggesting that if the barn comes down, that they would replicate the size of that building. I agree with what Paul and Marty have said, that that if the barn is no longer there, but they do need 1,000 square feet or 1,500 square feet of storage, that they could, that they could have that as a permissible accessory use.
Well, I think they could, but I would remind you that my understanding is this childcare center, as designed, was designed to their specs, presumably with all the storage they needed. So, but I suppose I could be convinced.
I don't disagree with that.
Would we put that as a condition with regard to the removal of the barn, that a storage building of X square feet could instead be constructed per a site plan that would be approved by the planning board, something like that?
I would have no objection to that.
Chris, what do you say? I see you have your hand up.
I think it's perfectly fine for the planning board to signal an openness to allowing an reasonably sized accessory structure for storage in the future, but I would be a little concerned about including simultaneously requiring the applicant to demolish a 2,500 square foot barn, but allowing them to put up a 1,500 or 1,000 square foot barn. I would not set I would not discuss what would be appropriately sized, because I think you're running a risk if you're saying 2,500 is too big, but 1,500 is just right, of the applicant coming back and saying, you should have let us keep the 2,500 square foot barn just by virtue of it being an existing structure that we don't have to build or buy.
Yeah, but Chris, you're talking about a difference between the kind of shed I think Paul's talking about is a single story, maybe 800 square foot kind of thing versus a huge barn, a very large barn of which there's no demonstrated need for the use.
Okay, then there's no need to have, as part of the condition that you're talking about, anything about allowing a smaller storage building to be constructed, just silence on that. I think that's what we're being told is the better approach in any event.
I agree with that.
Okay.
Concur. So.
But I think we have to get to, I don't know whether the others agree with me, that if the building stays as presently set on the plans at 64 feet, that it would be an unreasonable I believe it would be an unreasonable regulation to tell them they have to take down the barn simply because our regulations provide you can't have two non-residential buildings. I think that I think we have to have a good reason to tell them to take down the barn. And I'm going to say it again. I know I've said it before. I think the major part of the bulk here is the daycare center, and it's separated from the barn by the 5 parking spaces lot with the circular in it. And I think with these plans as constructed, if the daycare center, if we don't want them to move back to daycare center, I think it would be an unreasonable regulation to say you have to take down the barn simply because we have a bylaw that says you can't have a second building.
And the bulk would be too great. You don't buy that.
Not with this size lot. This is a huge lot, and it's set back from the building.
It's set back by about 65 feet.
Yeah. Well,
I mean, I've measured it. It's rough. I mean, it's rough based on the scale of the plan. It's roughly 65 feet between
you're right. Yep.
the parking.
Between the back of the daycare center and the barn.
If you include the 5-foot sidewalk,
Right.
then it's 75 feet. But Gene is satisfied with the current setback as is.
I am.
I understand that. I'm not satisfied. I don't think Paul is.
I'm not.
Marty, where do you fit on the setback?
My preference is to set it back further.
Would you agree to set it back to the most analogous use, which would be the distance of the temple next door?
Which would require the removal of the barn, you mean?
Or incorporating the barn in the design?
The barn ceases to be a barn.
Yeah.
You're saying that basically you're taking the outer structure of the barn and preserving it, and taking part of the. I mean, if the barn is 2,500 square feet, and the daycare center is 10,000 square feet in terms of floor area, and you're saying push back the building to Temple Aliyah and incorporate the barn into it, you have to cut out a good chunk of the building, and you're not going to wind up with 12,500 square feet. You're saying, you're going to wind up with 10,000 or 11,000 square feet by doing that. Because my looking at these plans, if you just push the building back and have the back of the building be at the front of the barn, the front of that building is not going to be at Temple Aliyah. It's still going to be closer to the street.
Well, I want the building, I would prefer the building to be set back further. I think that it's necessary that it go back as far as the temple building is? I don't think that's necessary to satisfy me. But I am also worried that once we seek to move that daycare center building, that the process is going to get very messy. And that's what I was trying to get at last time we met, that I think the process could be very difficult. And would it take more than 3 months to resolve? It might, in which case there's a real problem, because I'm not going to be on the board anymore. So should that be a factor?
What do you mean by that more specifically, Marty? You think it'll take 3 months for us to arrive at a decision?
Well, once we say move the building, they're going to have to do some re-engineering, draw new plans, submit them to us. We're going to have to approve them. There might be difficulties. I don't know. That's going to take time.
So, Chris, do we need Marty to do that, or can a new member of the board because we will have already issued the conditions?
Yeah, I think in terms of process, with a site plan, there's, I think, a couple of different approaches you can take. You can approve, the easiest, obviously, is to approve the site plan that you have in front of you. That's easy. They can take that site plan to the building commissioner. and pull a building permit after the appeal period runs. If you want to require the applicant to make changes to a site plan, you can write a decision that describes those changes in hopefully some great detail so that the applicant can make all the changes you've required of them and put them on a new version of their site plan. But I think for what is effectively a by right use, you must draft a decision that they can make the necessary adjustments to, and then go to the building commissioner for a building permit. You can't, I don't believe you can require the applicant to take your site plan approval decision and come back to you in 3 months for a new hearing and another level of review. What you issue must effectively be an approval that the applicant can go take for purposes of applying for a building permit.
But we can go so far as to review their changes to make sure that they comply with what we've asked for, right?
I would be concerned if that next round of review involved any kind of discretion whatsoever. So you could draft something that is, I think, requires the applicant to make a change. And if that change has been made objectively, yes or no, I think the building commissioner would be the appropriate authority to conduct that level of review. Any condition that requires the applicant to come back before the planning board 3 months from now or 6 months from now for a public hearing, or any kind of discretionary review is going to be vulnerable to attack on appeal.
So I shouldn't be worried about the fact that I'm not going to be on the board in 3 months, is what you're saying.
If we draft the appropriate decision.
Right.
I don't see, if we say that the building has to be pushed back, if we don't approve this plan, they have to reconfigure the parking lot. I don't see where the four of us are going to reconfigure the parking lot for them. They're going to have to draw new plans with a new parking design, which may very possibly have to include new landscaping. Probably will require a totally different landscaping plan.
Right.
Which Chris says they can't bring back to us for any kind of discretionary approval.
You would need to draft a condition describing exactly what it is you expect of the applicant, both in terms of where the parking's going to go, how much of it there's going to be, and if there's any changes to the layout, you would need to describe that too. And you would need to describe in some detail exactly what landscaping you're looking for. And the person that would review whether the revised version of the site plan complies with those conditions or not would be the building commissioner when the applicant applies for a building permit.
Jean?
Yes, you mentioned, Chris, that the final arbiter of whether the condition has been complied with would be the building commissioner. But could the town engineer, could it be expressly said that the town engineer has to approve the plan? I'm thinking of issues like drainage that might result from a slightly different, from a differently arranged parking plan, and maybe the slopes would be different. And also the fire chief be satisfied, and that sort of thing, the department satisfaction.
That's a good question. I think we could get away with that. I think my only, I think that would work, provided that the town engineer is reviewing, the new drainage calculations for compliance with state regulations. Mm-hmm. And if they comply with whatever those state regulations, the minimum requirements are, then the town engineer would sign off on it, and that would be that. Similarly, the fire chief would be reviewing it for, compliance with the NFPA. He wouldn't be expressing a preference as to whether he might like, one layout better, slightly better than another, based on his discretion. I would say that if it complies with code, that would satisfy your condition. The key element here is that all of the discretionary review needs to be done when you issue your decision. If there's an objective criteria we want them to satisfy when they revise their plans, I think that's okay. But we can't leave any discretion left to be exercised by either the town engineer or the fire chief or the building commissioner. It's either, it's got to be, black or white.
Thank you.
So where does that leave us?
Well, I think we've got basically a 3-to-1 quote vote, which I realize we didn't vote, that Marty, Jean, and I think you, Adam, are satisfied that the barn is not a legitimate accessory use and structure, and it constitutes too much bulk, and we would want to see it demolished. Paul, however, is inclined not to agree with that, but only to the demolition of the barn would only be because it would be necessarily be required. There would be no other way to comply with whatever setback rule the board sets. Am I expressing that correctly? There's sort of a 3-to-1, and that's fine. Why don't we move on and talk about setback?
Paul, looked like you had a subsequent thought there.
No, I was just gonna say that if the vote is 3-to-1, that the barn is not a permissible accessory use, and therefore we can enforce our regulation to say you can't have two separate non-residential structures, and the vote's 3-to-1, I change my vote, and it will be 4-0.
An accessory building.
Correct, not
Non-accessory
accessory
building, right.
use, it's accessory
Right.
building. I just made that note myself.
Right.
Yeah.
Non-accessory building.
So now we're 4-0 on the barn. Let's chat about the setback. The last we left it, it seemed as though it was effectively 3-to-1. Adam, Marty, and Paul, that the building should be set back somewhere between 100 and something and 200 square feet, so 250 feet from the street. And Jean, you were satisfied at 64 feet in its current
Right.
form.
That's right.
If there was to be a setback, Jean, that was greater than the 64 feet, would you want to keep it in line with the most analogous use, or a more subjective criteria of somewhere between 64 feet and 200 feet?
I'm sorry, Adam, I don't understand the question.
So in terms of the setback, if you were to agree to increase the setback, would you consider setting the building back to the most analogous use in the area, which is Temple Aliyah, which would be somewhere around 200 feet? Do we all agree that the most analogous use in the area and the most analogous building is Temple Aliyah?
It's a much larger building than was proposed.
I'm not talking about the size, I'm talking about really the use.
No,
Is
but
it
the
the most
size goes to
analogous
the
use?
setback, Adam. The size goes to the setback. What's a reasonable setback for a building of this bulk?
Which is why you're saying that it's less, that it's more than where it is and less than Temple Aliyah, because it's smaller than Temple Aliyah.
Yeah, that's my position.
I find that reasonable.
So on that basis, somewhere around 100 and, what were you suggesting, Paul, 140 feet or so?
I was suggesting that it would wind up being about 130 feet if we allowed them to keep the barn, and we just pushed it back to a place where they could have a walkway between the barn and the building. I would be not happy with that, but I would be satisfied with that.
But on the basis that
On the basis that the barn has to come down anyway, I would move it back about 150 feet or so. 150 to 160 feet. I think that's far enough away from the street on a building that size. And then you've got landscaping. It'll, and they've still got plenty of area to reconfigure the parking. They still have play area. I mean, they can have play area in the front of the building now. They put up a fence so that it's shielded from the, from the street if they wanted to. I
There's
wouldn't
still
make that a
lots of room
requirement. That's up to them as to whether they want to enclose a play area in the front of the building,
there's still lots of room on the side too.
Yeah.
Gene, if the three of us agreed on a setback of 150, 155 feet, would you consider that?
I have a number of reasons for not wanting to change the setback that is proposed. First of all, I think that given that it's almost twice the setback in our zoning bylaw, it would be considered an unreasonable regulation. And then it also, the requirement of moving the building back, unless we say that it should be moved back and be built precisely as shown on the plan, same circle of cars coming in and out, and so forth. It's just moved back. If we did that, then my second concern would be alleviated, and that is, we're told by town council we can't come back and have another bite at the apple on the site plan approval. So if we're satisfied with the way it's laid out, and the advantages would get a longer driveway, which certainly is an advantage, then it could be very clearly expressed in our conditions in that manner. And I think that landscaping would only be, I guess you'd need more landscaping in the front, and it seems like we could describe that as similar to the landscaping proposed, but it would be, I think we could describe that. So if that's the case, if that's what we're talking about, with the removal of the barn, that we're simply talking about move that exact building with that exact layout back, then I'm less concerned about the fact that we can't really review that site, a very substantially revised site plan. And so my only concern that's left is the concern about whether we will ultimately prevail on the reasonableness of requiring such a setback.
And removing.
So if the other members of the board want to do that, as I said, go ahead. And when it comes time to vote on the permit, I mean, I have a couple of weeks to think about it until our next meeting, but I feel as though I would not deny the permit. I would approve the permit. But I'm not going to say that I think it should be done.
Paul?
Yeah, I'm staring at the plan, and if the barn is removed, I think what Gene is proposing, there's room there to do it. You're just having a longer driveway. You're moving the building back. You're having a longer driveway, and everything else that appears from the rear. When I say the rear, if Central Avenue is west, then the east. To the east of the building, everything that's to the east of the building now is just moved out the extra number of feet that we're doing the setback, it looks to me like that can be done. I think there's, the lot does narrow as you go back, but it looks to me like there's still enough width there to be able to do that.
And an advantage, as I mentioned in my comment just now, is that you do have the longer driveway leading up to the drop-off area. And I've been very concerned about whether there would be traffic backup on Central Avenue, and wanting to focus a condition regarding, police presence to direct traffic, a report from the police chief. If the report is adverse and there's nothing they can do about the traffic backups, they're happening all the time, then that would need to be addressed. And so I've been thinking along those lines. If the building is moved back and there's a longer driveway, perhaps that's not, that kind of condition is not so necessary. I still think you need police presence at the beginning to make sure everything's
agree.
moving smoothly.
I agree.
But maybe I'm a little more comfortable about that.
Okay, so if we wanted a 150-foot setback, the building is being moved back an additional 86 feet. Everything's just being pushed back 86 feet.
Which means, by the way, if you look at the site plan, the back of the building, the east side of the building would basically line up pretty close to where the back of the existing barn is.
Yep.
Give or take, but somewhere around there.
I think that the rear parking lot might be tight in terms of the width of the lot.
But they could have parking on the side, on the southern side. And they could make use of the rear section for an outdoor play area. And they could also have some parking in the front, which I'm not opposed to as long as it's screened.
Yeah, but now you're talking about they're coming back to us with a plan to review, and Marty's not going to be here, and that's a problem. We'd have to have a plan that says that just says you take what you got and you move it back.
I see what you're saying.
I guess my only caveat would be, I'm not sure I would go all the way to 150 feet. I'd be
Yeah, and I think it's tight for the rear parking lot. 140.
130 to 140 maybe.
Yeah.
So 135 feet.
Something like that.
So 135 feet is roughly the length of the current building now. So that puts the rear edge of the building about halfway where the barn is.
You're adding another 71 feet. You're pushing it back 71 feet from where it is now.
Now, can we describe,
Yeah, that looks like that'll work.
but I think that they could modify the parking, and they could combine those 5 spaces and the 6 spaces with the 19 and basically have 30 spots altogether, pretty close to the building.
But then you don't have the turnaround and the drop-off area. Gene is concerned about the drop-off area, which is where you've got the 5 spaces and the loading dock.
Mhm.
This is why you can't have them coming back with
I understand
a
the
new
need to
plan
not
because
have them
Marty's
coming
not
back.
going to be here. Where are they going to put the loading dock? How are they going to configure the drop-off area?
Well, if you just took the whole site plan, beginning where the front of the building is now, and just took your scissors and cut it and moved back 71 feet, wouldn't it still fit? You're saying it wouldn't fit.
No, I think it fits.
Yeah. So isn't that the answer?
Adam is just saying that they could reconfigure the parking. But I'm
And they
saying,
could- I'm saying they could reconfigure the parking. They'd still have enough room
Oh,
to
they
do
could. Oh, yeah.
to do the
Yeah.
drive, to do that, the drop off. They could still have the loading dock. They have a lot of width. When they lay out horizontally, effectively, those 11 spaces, that's a lot wider than the width of the 19 spaces that they have. They could easily combine that. Still have a loading dock and still have a circular drop off scenario.
Could
but
we,
how, but how
could
do
we
you do
simply say
that?
that they may do
One at
that?
a time.
They may do that if they want to, as long as the engineering, works.
Right. Paul?
Without our approval?
Right.
It would have to be without our approval. It would just have to be with the engineering department and the building inspector and the fire department
Mhm.
I'm
enforcing code.
I'm fine with that.
And somebody please clarify for me, just so I understand what that second option is.
So we moved the building, right now the building is set back at 64 feet. We're proposing to move it back to, I think, 135 feet. So the front of the building, I think, would be, if you look on the site plan on page sheet 3 of 9,
Yeah, I understand shifting everything back as it currently presents itself on the plan in front of us, but you talked
Mhm.
about altering the parking. I didn't quite understand what that discretion was.
He's
Oh.
giving them the discretion if they wish to reconfigure the parking behind the building. He's giving them the discretion to reconfigure the parking behind the building.
But retain but retain the drop-off configuration?
yeah. And the loading access.
So the circular driveway and the loading dock stay the same, but the parking lot at the back can be reconfigured with the 6 parking spaces. The 9 and the
Well,
6 can be reconfigured.
If you look on the site plan on sheet 3,
Yep, I'm
if
looking
you
at it.
see where it talks about the barn, and
Yeah.
north of that, there are those 6 spaces.
Right.
If you move those 5 spaces to the left of what's currently the barn, that can work, and you still have enough travel space, and you still have the room for the loading, and you still have the room for the drop-off structure.
Okay, you still have to retain the parking where that area where you've got loading and 2 handicap spaces and the drop-off area, that has to remain the same.
It does. I agree.
So what you're basically saying is they can take the 6 parking spaces that right now are to the north of the barn
Hmm.
and reconfigure that any way they want with the rest of the parking lot that would be behind the
I mean, yeah,
those 5 spaces.
yeah. I mean, I see it slightly differently, but that's the same effect. I see that if they push all this back a little deeper into the lot, those 5 spaces in the loading works.
Yep.
With the 6 spaces north of it, with enough access, and with the loading, and with the circular, and with that drop-off design.
Yeah. And we're giving them the discretion to figure out what they're going, how they want to configure the 25 spaces.
Yeah, well, you mean the 30
Yeah.
spaces?
No, there are 30
25.
spaces total now.
Oh, you mean then the 11?
5 spaces with the loading dock, we're saying that configuration has to change because that's where we have the loading dock and that's
Yes.
where we have, and that's where we have the drop off.
Has to change or has to stay the same?
Has to stay the same. It's those 6 spaces that right now are to the north of the existing barn that they can reconfigure any way they want with the 19 spaces that right now are to the east of the barn.
You're saying just reconfigure those 6 spaces?
Yeah,
Meaning they could go in the front to the west of the building.
no, they have to be in the back.
I think if I'm using my ruler correctly, even if it were just completely shifted without any change, the back of the rear parking lot would be out about 30 feet away from, say, the O'Connor property. It would still be a fair distance away, so might not be a problem.
Mhm. Good.
Though it would involve removal of trees, of course. Maybe we want to condition that if any trees over a certain caliper are to be removed, because that was an issue about moving farther back, was that at least that was pointed out by the applicant, because of course they don't want to have to move farther back, is that it would involve removal of large trees. We could condition that any trees over a certain caliper that are necessarily removed because of the relocation have to be replaced elsewhere on the lot.
They claim that, of all the trees that they moved on this site already, they were all diseased.
Yeah, I happen to, yeah, I noticed that. There's certainly huge trees if you ever went there and looked at the
I did.
the stumps that are left there. I just want to make sure that there's sufficient buffer for the butters for the parking. But I know.
I think that's reasonable.
Just-
I think there should be a buffer. There should be some
Yeah.
land screening for it, for sure. I mean, I think they intend to put a fence around this, the southern edge, and I think around the parking too. Right?
Is there is there to be a fence along there? I don't see a
I
fence.
don't think that's on the plans.
No, there's the only
says-
fence that's shown now is behind the building where a playground area is created.
But that
and it
line
says
continues,
vi-
that line, Gene,
Vinyl
continues,
fence.
that line continues
Yeah,
All
all
the
the
way-
way back.
all the way back and around the parking.
Oh, that's right. Oh, I see that it does. All right, so the parking would be screened anyway by the fence. Okay, I hadn't noticed that. Thank you.
Yeah, it's a 6-foot high fence.
Yeah, and
Exactly.
of course we want, we've already discussed one of the conditions would be that that's going to be changed from white vinyl.
Well, either white vinyl to green or something, but or a wood fence.
So the location of that fence vis-a-vis the building is going to change. And the shape and size of the play area might have to change too.
That's right.
Why would that be?
Well,
Yeah,
if you move the building back, where's the fence going to be now?
There's still quite a bit of space between the fence and the adjacent lot line, isn't there?
Should be.
Yeah, but I'm saying vis-a-vis the building, the childcare building. Right now, the fence comes in sort of mid-building,
Yes.
looking east-west. But now, where will the fence come in? At what will be the front of the building?
Well, no, the fence would go along with the building as far as the relocation of all the structures, the whole thing.
So if you move the building and the fences back, that's
Yeah.
definitely going to compromise the size of the play area.
No, I don't see what,
No, not if it
I don't
just
see why it would.
stays with the current dimensions.
Yeah,
Leave the fence where it is in relation to the building.
right.
It starts basically close to the middle of the building.
To be more precise, what Marty is saying is not entirely wrong. I think what ends up happening is that fence, because of the shape of the lot, that fence comes a little farther south and gets a little closer to the Heidemann's property and Greg Darish's property and
Yes,
into Nicole. It gets,
Oh, it does, yes.
yes, it
but
does.
they still have the same total area.
Who still has the same total area? I don't see how the playground is the same size.
Looks to me like it'll be the same size.
Let me just map it out.
I see why it wouldn't be exactly the same.
If they want to move the fence a little bit farther west, they want to have the beginning of the fence a little bit farther west, I'd have no problem with that. Gives them more playground area. It's up to them.
Anybody have a problem if they put a playground in the front?
I got no problem with that. That's their, I don't know whether they would see any safety concerns for the children by having it in front. That's why I was saying that, you know, you could put a playground area, a totally enclosed playground area in the front. You know, when I say enclosed by a fence, a 6-foot high fence.
So
No.
I got no problem with the playground being in front if that's where the child care center wants to put it.
So
I wouldn't either, so long as it was fenced safely and perhaps landscaped.
just to be clear, I've mapped out the structure of the building, including the fence, moved it back on the site plan. And the new buildings, to reconfirm, yes, I'm right. That new building lines up here. The fence. It's the same player. It's the same total area for the play space.
I don't see how that could be, but
I can show you, it's a little easier to show you physically in person than it would be on the tools of Zoom, but if we could bring,
you can sketch it and fax it to me, I suppose. Anyway, okay.
so,
I think the location of the playground is kind of linked with the interior floor plan. It's relating back to the play space. It's relating back to where the doors have been sited along that elevation. So I
none
think
of
the
that
activities in
changes.
the interior of the building are integrated with the activities out on the exterior of the building.
Correct, but none of that changes, Lee.
Yeah,
We're not
Marty,
changing
the fence is still going to be on the property. It's not going to extend onto the neighbor's property. So
Yeah. Perhaps we only make things more complicated by saying they can relocate it and put a playground elsewhere. Just move everything back.
Yeah.
And I keep saying this in trying to be involved in the discussion, even though, as you know, I still have my reservations, but I can see advantages, as you all can, right?
So do we have consensus to increase the setback to 135 feet?
I still have the reservation about it, and I encourage you to make a decision on that without me at this point.
I'm fine.
And
I'm fine moving it back to 135 feet.
Marty?
Okay,
Adam, you there?
I'm there.
So it's 3-1, Gene.
Yeah, I know, I understand.
Yep.
I'm being stubborn, sorry.
Why
Now-
change now?
So now, should we turn to some other conditions? I think one of the easier things to pick off would be the environmental impact, which I think we would simply condition on, the parties have already agreed, basically, that the town will pay for an environmental engineer to survey the site, to survey the site and determine what testing is necessary. And based on the test results, determine what, if any, mitigation is necessary. And that the developers is required to do those mitigations that the environmental engineer recommends.
we just adopt the Board of Health's recommendation.
Yeah,
Well, it's not really the Board of Health recommendations. It's going to be the recommendations from the environmental
No.
engineer.
the condition that you're proposing is basically the Board of Health recommendation.
Right.
Yes.
Right.
And by the
But
way, they're talking about specifically, I believe they're talking about specifically hiring an LSP.
Right.
So to call it an environmental engineer, let's specifically call it an LSP.
What's the
Excuse
difference
me.
in the skills? Yeah, go ahead. Lee.
I guess before we go too far down on this environmental road, I mean, I know we talked about the setback, but John Diaz, I think, is present in the audience. It might be helpful to get his input on the reconfiguration we just discussed on the parking lot and moving the building back, just to make sure we haven't missed something there.
Good idea.
Okay. John, happy
Hey
New Year.
guys,
Happy New Year. Thank you for being with us.
you caught me at my best.
We did.
Hold on a sec.
No problem.
There you go. Now I can hear you guys.
Happy New Year and thank you for being with us.
Happy New Year. How are you?
We're good. We're getting into the meat of this stuff now.
Yeah. No, I just raised my hand. I think it sounds like, Adam, you probably did what I did. I just kind of cut and paste the PDF and drag the building back. Just if you guys want to kind of see what it looked like, I can share my screen if you want.
Yes, please. That's
That'd be
great.
great.
Let's see. Let's see that, and then. So am I sharing the right screen?
Yes.
Okay. So that's kind of what I did here. I just dragged it back. So it's basically 135 feet off the road.
Yes.
Kept this the same. And then you guys were talking about like some parking things here. I just kind of doubled the parking over here since the building wouldn't be there. So you could have kind of a circulating parking, something like that.
Excellent.
And keeping this the same. So that way you drop off and you'll have your handicap spots, and whether you keep these two spaces or make them extra handicaps or vans or whatever, but the bulk of your parking would be over here. You could do something like that. And that
That's
gives you
neat.
the extra distance along here for the queuing.
Which will take more cars off the Central Ave, right?
That was my question too. Yes, John.
It provides more queuing. I wouldn't necessarily, it takes more cars off because you're not generating more cars, but it provides extra space and a longer point for you to queue, so.
Well, John, I was particularly concerned, and I think the neighbors are too, about backups. Whether those backups occur in the northbound lane, because people going to the daycare can't turn in, or the southbound lane on the other side for the same reason they can't turn in. And I know they have the second lane. So
Yeah.
ideally, if they're not able to get in the first queuing lane, the cars should go in the center lane and go into the back.
Yeah, so basically by doing this, you're giving them another 6 vehicles in the queue.
Yeah, so
7 vehicles.
that would take care of whatever concern there may be about cars backing up.
Yeah,
I realize it doesn't change the total ins and outs and the total traffic.
right, yeah.
Yeah. Okay, well, that's very helpful. Thank you.
All right. But other than that, I mean, yeah, I think if you're just dragging the building back and taking if the barn goes, it lets that parking in the back be more functional to you, because you won't create a dead end in the parking lot if you can double it up and have some circulation around it, so.
So you've added more spaces.
Basically what I do is I just took this and shifted it over where the barn was, so you can get 36 spaces just in here.
Yeah, which gives us a total of 41 spaces.
Roughly, again, I mean, this is obviously just cutting and pasting a PDF, but yeah, you can get more spaces in back there, so.
So I would, since they've come to us with 30 spaces, and they've got 40, and John's rough proposal here brings it up to 41. I would just condition it to say that to have a minimum number of spaces, whether that's 30 or 35. And, if they want to have the full 41 spaces, they're free to build it. And our condition will be a minimum number of spaces.
And if they were to build
Paul, are you saying that our condition would be, the minimum number of spaces would be as they were originally proposed here?
Well, that's 30.
That's 30. And then but they would have the permission to have more spaces, a certain amount of more spaces. That's the idea? Sure.
and if they were going to go toward the minimum, I would want, I think, the southernmost spaces to be deleted, to pull the parking spaces further away from the neighbors, the Darrigs and the O'Connors.
Right.
Oh,
I like the idea actually of these 41 spaces. I think it provides ample room. The other thing that we're dealing with parking is, the daycare facility has events with parents. And, COVID's a little different right now, of course, but I would want to make sure that we had a condition that, they weren't really, they wouldn't really, if we had 30 spaces and they were having an event at 4 p.m, like a Halloween party for the whole school, and they are at 115 students and maybe 90 cars, that's impossible to fit, obviously, in 30 spots. So they would be prohibited effectively from doing that, and I would want a condition that would say something like that.
Oh, we have conditions like that about events. I mean, we can incorporate that in. It seems to me though, you don't want to overbuild parking. And I don't know that we want to force them to take more trees down to overbuild parking.
the trees, right? You'd be taking trees down.
You're taking trees down, you're putting asphalt down. I mean, is that, if it's not necessary, why are we doing it? I mean, one strategy would be to live with the smaller number, maybe make them show, if you're really concerned about it being insufficient, have them show reserve parking which if at some future time is required, they have to build it, but that it's not built now if it's not necessary.
Mhm.
Well, instead of asphalt, can we require some other surface?
I was just gonna say, there is the like structural grass and other materials that you could have for an overflow parking. I don't know if you've seen them. It's actually a plastic, like, well, not, I say plastic, but rigid system that's in the ground that's planted with grass. So it looks like grass, but you're actually driving on a hard surface. But
Yep,
I
it
should
was
probably
still-
leave before I say too much. So.
That would still involve the removal of trees. And up
There are
until
not a
this
lot of trees
point,
back there, Gene. There are
up
not a
until
lot.
this point, we've been satisfied with the 30 parking
30.
spaces. So, I hesitate at this time to start talking about how they need more parking.
I'm with Gene on that.
I agree. I agree with that.
I would have a strong preference towards providing an option for some additional parking.
Oh, we're talking about a minimum number of spaces, Adam, that they can have that they can have more spaces if they want it. If they want to spend the money to take more trees down and build more parking,
Right, there's.
more power to
right.
them.
But when
Are
we
you
set
sure
out a-
about that, Paul? I don't, why would we want to, why would we want, some towns are actually putting maximums on parking spaces. I don't know why we want to have an open-ended number of parking spaces they can
Well, we can give
construct.
them a minimum and a maximum then, but I think where the basic concept is that we're just telling them to take the current plan and move it back. We're at 30 spaces.
Mhm.
Mhm.
But, and we have had some pushback from the neighbors who say, well, if you look at the different ways to determine how many parking spaces are supposed to be there, based on square footage, I think the neighbors were at 38.
Correct.
So
Uh,
minimum of 30 and a maximum of 41.
Right.
Why go to 41? Why not 38?
Because John Diaz has already presented us with a nice plan that shows 41 spaces.
That's
And if they just want to use John's plan, they can do it. If we
Right.
limit them to 40, then they got to figure out where to cut out a space from John's plan.
Yeah.
Well, I think John's
I'm
plan's
gonna
a
say
sketch.
goodnight now, guys.
I don't think John intended it to be a design plan, but
No,
John can
no,
speak
no,
for
I-
himself.
Marty, what
I
was
was
what were you
I
saying?
just sketched it up so that I could understand what you guys are talking about, and figured I'd raise my hand just so you could see it, because it's easier to see something on paper than
Yes.
to talk about it. So I'll be on. If you need anything else, just bring me back in. But I'm gonna check out.
Thank you, John.
Thank you.
All right, take care, guys.
Thank
I,
you. You
I
too.
would have the minimum be 30 and the maximum be 38. I don't see a good reason to go to 40 or 41.
Okay.
I'm fine with that.
I'm
If
fine with that.
it's going to be 30, I definitely want to pull the spaces off the southernmost portion of that parking area and definitely landscape it so that there's a sight buffer from the neighbors to the south.
In addition to the fence.
Yes.
Yes,
I agree
and
with
John
that.
Diaz's sketch showed the parking area in the rear being moved to where the barn is now. If you simply said everything's moved back a certain number of feet, we're not allowing for that. We have to make sure we use language that either requires that parking to be no farther. I could set a maximum number of feet from the front lot line. The parking cannot be any farther back than that maximum line, so that the parking does get moved. You know what I mean? To where the barn used to be.
Yes,
rather
I
than just
understand what you're
leaving a
saying.
Big empty place.
Right.
That's, yeah. And I say that because, I've always been a tree hugger, right? You guys know that. And I don't want them to be just moving the parking back and unnecessarily into the area that's treed. And also I agree with Marty, about trying to reshape that parking so that it doesn't go any farther than the originally proposed parking to the abutting lot lines.
To the south, right? What about lighting?
Yeah, let's talk about lighting. How has that been left?
We need a revised plan on the lighting. The design review board has some suggestions on how the lighting needed to be changed, and it has not been reflected on these drawings.
So who is competent to review that design, that revised plan, and make sure it meets certain standards that we expressly set out in our decision?
I would say the design review board and the engineering department.
Is the design review board exercising the kind of discretion that Chris said was a problem?
He said it was a problem for us, not necessarily the design review board.
Okay.
Oh, Chris,
Go-
got it.
Go ahead, Chris.
No, it's a problem for anybody to be exercising discretionary review of the plan after you issue your approval.
Okay.
So if you're saying that they need to meet some standard, and that's fine. But if the question is, do they like it or not, or want to improve it or not, that's going a little bit too far.
I stand corrected. Thank you.
We did leave our hearing open for the purpose of getting input from the design review board on the lighting plan, did we not? I thought that was one of the express things we listed and said that we needed. Lighting, yes.
Right.
Input.
The design review board said, this was basically their recommendation. They said the 24-foot light highlights at the north side of the proposed driveway have a long distance between them, which would result in bright and dim spots. And I think they recommended that there be 4 poles, I think, rather than 3. And that the
20
poles, I
feet.
think, be reduced down to a height of 20 feet.
From 25,
Okay,
that's
so
right.
we know exactly what we're supposed to do here, huh? Okay. Is that new, Lee, or was that in an earlier?
That was basically in their, I think in their last memo to the board,
From
which
August.
was in
From August.
August.
But it
And that's
never
what they said. Let me
was,
go on.
never was responded to by a change on the plans. Is that right?
Pardon me?
But that recommendation was never responded to by a change made to the plans thus far.
Right, and then they went on to say, as long as exterior lighting complies with the building code and zoning requirements, and the original comment about height and spacing of poles at the north side is addressed, we see no issue.
Okay, so we
As noted, the
can
facility
have a
will shut down,
condition.
will shut down site lights early in the evening.
Okay. So all we have to do is reference that recommendation and,
It's a
They have
plan
to comply with it.
modification
okay.
and a condition in terms of how the lighting's gonna be managed there.
Mhm.
What about the aspect of the lighting that was pointed out to us that people coming down the driveway are going to shine their headlights right into the houses across the street? What do we do about that, if anything?
The only thing that I could think that could happen, if it's true that those lights are going to be shining in across the street, would be to effectively have the developer pay for additional screening on the neighbor's property. But I don't know if that's going to happen here, and I don't know that that the driveway for this lines up with the living rooms of the neighbor's house across the street. There's no doubt that when they're turning in and out of the driveway, their lights are going to be, there will be some lights.
They have that everywhere, and the houses are set back 100 feet.
Yeah, I don't see it as an
Look at-
issue really.
Marty, if you look at the plans,
Mm-hmm.
the driveway, if you see where the driveway is coming out, directly across Central Avenue from the driveway is pretty much the center of the driveway is the lot line between the two houses.
Yeah.
So it's not where the house is. It's the lot line. Coming out of that driveway, you're not shining into the house. The house would have to be built straddling the lot lines.
Well,
See what we're talking about?
no, I understand what you're saying, but, you know, a car coming down that driveway wanting to take a right is gonna make a little bit of a turn, wait for an opening in the traffic, and then go into the traffic. But as he takes that little bit of a right, his headlights are gonna go right into,
Tasha's house.
oh, really? Yeah.
Not Peter Lyon's house. It's gonna go into Natasha's house.
Yeah. I don't really see how that can be avoided.
I don't either.
And those lights, as they make that little turn, go squarely in the middle of Natasha's property, not to the edge of it.
Well, for the moment, let's defer on what we might do about that. Let me just note that it's 10:30 and we have more on the agenda. I don't know what you want to do here.
So I'm prepared. So I think we bit off made a number of major decisions here. So I'm happy to stop here and continue with the agenda. If Chair Paul, you're open to that.
I am.
Don't we have very little left? Shouldn't we finish up? What else do we have that we can advise Lee on starting to prepare a decision? The only thing I can think of is snow storage. We want to make sure we have a condition that the minimum number of parking spaces be kept free of snow and snow be cleared. Just some condition like that. Was there anything else? We already talked about lighting. We already talked about the Board of Health report. The fence, we already talked about the fence. And we have a letter about the sewer, about what they have to do. They said they have to pave Central Avenue from gutter to gutter.
We haven't talked about the traffic yet and the conditions on that.
Well, if the setback is done and we have room for 6 more queuing spaces, I'm less concerned about, I had looked at the Newton decision on that huge project. Of course, it's a completely different scale, the Northland project in Newton. But what they did is they had to have a traffic demand management plan, and they had to, if the traffic in and out proved to be more than projected, they had to submit a revised traffic demand management plan, and all this. But I'm thinking if we have the 6 extra queuing spaces, we don't really need all that. And I was thinking ultimately, well, what is enforcement? And I was thinking ultimately, all we can say that's really clear is if they can't accommodate the traffic and it's backing up on the road, they have to reduce the number of students. Well, we're hearing tonight that reducing the number of students is one of the things that other towns had tried to do that they were told they can't do.
And furthermore, on further reading of those cases, traffic is not really, and we can ask Chris to kind of jump back in to verify this, but traffic's not really something that we can necessarily use to diminish, the size of the number of kids.
Yeah, there was a case expressly on that point,
Exactly.
Adam.
No.
So I don't know exactly what enforcement we would use if we did find out that cars were backing up on the road. What would we say in our decision that they have to do now?
I would recommend that we require that they have a traffic detail between the hours of 7:30 and 9:30 in the morning, and I don't know, 3:30 to 5 in the afternoon. I don't remember what their hours are, but basically,
Whatever
late-
the time that was shown as being the highest traffic time,
right,
I
right?
think between 4 and 6, I think they
4 and
close
6.
at 6.
Okay. So from 7:30 to 9:30 in the morning, and from 4 to 6 in the afternoon, they have to have a traffic detail of at least one traffic monitor. I don't know, do we specifically say an off-duty police officer or coordinated with the police department?
I think it's a police, I think we're looking for a police detail.
Police
Police
detail, I
detail,
thought was what we
okay.
said.
And for a minimum of 2 months from the opening. And after 2 months, if they feel that the police detail for those hours is not necessary, they may come back to the board.
And would we want a report from the police department at that point after the 2 months?
I don't know, the police department is really monitoring it. I mean, they're basically hiring off-duty police officers. Is the
Well,
police department really monitoring that?
We did talk about it also a study a post-construction study.
Right, I think John Diaz had recommended that
Okay.
when they were at 80% of their capacity, student capacity, that they would have to do a follow-up traffic study.
Okay, that's good.
And then I think the last thing was the retiming of the lights.
But then if the follow-up traffic study showed a problem, what would the solution be?
We don't know. We have to, we have to figure that out. Then we don't know what the problem will be, Gene.
So maybe we'd use a phrase like a traffic demand management or traffic management plan. They have to come up with a traffic management plan.
Chris, is that okay to do that in that scenario?
Because what if we get a follow-up traffic study, but there's nothing we can do about it? What good is it?
I mean, I think if we're continuing the board's deliberations to your next meeting, this may be one that I can think about a little bit between now and then. I guess my only, you guys, I have not heard all of the evidence over the course of the entire public hearing from your traffic engineer. So I guess my only comment is that whatever conditions the board wants to impose relative to traffic generation from this project, my only comment was that it should be guided by what you have in the record from your own traffic engineer, discussing what this project is going to do or not do.
Well, my recollection is, and if John Diaz is still there, he can raise his hand and we can bring him back in. But my recollection is that he was talking about, number one, a police detail, and number two, the reconfiguring of the traffic light at Central Avenue and Charles River Street.
And as well as a post-construction traffic study at 80% occupancy.
So what can we condition if the traffic study? The neighbors.
Suppose a continuation of the police detail requirement could be a condition if the traffic study shows. And the other thing it really seems to me that the only thing we can kind of say, this is bad, is traffic trying to enter the premises that backs up on the road. And if that's happening, I don't know how to control it other than with a constant police detail.
Oh, if they need a constant police detail, they'll have to have a constant police detail. This is why I'm just saying that they have to have a police detail for a minimum period of time I was suggesting 2 months. I'm flexible on that totally. And then they come back to us if they feel that they do not need the police detail for 2 hours in the morning and 2 hours at night every day. Let them come back to with an amendment.
I would
amendment.
like that. I
Yeah,
would like that traffic study to be peer reviewed. The information that we've had from, from their traffic engineer has not been entirely reliable, to say the least.
I thought we were talking about John Diaz doing it, weren't we? He's our guy, isn't he?
No, the proponent is supposed to do the follow-up traffic study.
Oh, excuse me. Okay. Mhm.
Chris, it looks like you're about to say something.
Only other comment I would add is that if along the lines of eliminating discretionary decisions down the road in what really is an approval of a by right use, to the extent you want the applicant to come back after 2 months of police details to ask the board's permission to lift that requirement going forward, we ought to articulate a standard as to what will entitle the applicant to that relief at that point. I'm not suggesting what that is or is not, but we should think about that between now and the decision. The applicant should be able to know what, I think it's fair for the applicant to be able to know what will entitle it to have the police detail go away whenever it is they come back in and ask for it.
Can we ask John Diaz as our peer reviewer to determine those standards and make that recommendation to us? Is the board okay to do that?
I think so. I know I keep focusing on traffic backing up on the road, but maybe that is not the only issue.
No, the issue is, if the police detail is doing its job properly, traffic won't back up on the road
Absolutely.
because the police officer is keeping it from doing it.
That's right.
That's why the police officer is there.
Mhm.
So, that's not a standard that we will be able to have. We can't say, well, if traffic's not backing up, then you don't need the police detail. Well, that's not necessarily true, because maybe the reason that the traffic's not backing up is because the police detail is doing its job.
Well, I think it's the study that's going to show you. It's the post study that's going to show you if anything's required. The actual study of what's happening on the ground after it's operational.
And then Chris, they need to, our peer reviewer would also need to articulate what the standard would be, for either any additional mitigation or to maintain the police detail, right? Not just the standard of what the minimum standard is to remove the police detail. They would have to set up the standards for, like, if Central Avenue is worse as a result of this thing, and additional mitigation is required, what do we do?
Well, they could add more parking in the back so that cars can move up in the center lane and park so as to avoid backups.
If
Something they could do.
Right. If cars are not parking, but are queuing along the front entrance to drop off, and that's what's causing the backup, make the car, the applicant ought to be able to come up with a plan that will, if they have ample parking on space, and with between 30 and 40 spaces, they really ought to. Cars, there's a way to make it so cars don't back up on Central Avenue.
Mhm.
So to me, that's a management question, and you can certainly task the applicant with addressing that.
I hate to divert the conversation, but I just thought of something. We need to have a condition that we need to see a signed lease between the property owner and the Needham Children's Center.
Mhm.
Chris, can we say for a minimum of 5 years, minimum of 10 years?
But we have case law that per this spreadsheet that Chris prepared that shows that you don't need You don't need a tenant for any of this stuff.
We are basing our conditions on the representations from the operator of the Needham Children's Center as to what her operations are going to be. Those are the cases where situations where the one case was a situation where there was not an operator in front of the board telling the board how the operation was going to be run.
That's valid. I agree with that. Chris, does that hold?
I don't know exactly how you want to structure that in your conditions. No one is going to be able to make use of this decision other than a licensed childcare operator. You know, you can draft the decision in a way that requires this building to be occupied and managed by a properly licensed childcare facility. In terms of requiring a lease, I would not set any minimum or maximum on the length of that lease. I would simply condition it on the ongoing existence of a licensed operator.
And I'm not saying, can we require that there simply be a lease? Because otherwise, what contract is there?
Or ownership. I mean, somebody could buy the property.
Oh, a daycare
a
provider.
year
buy
from
the
now.
property. Yeah.
I don't, as long as there's a daycare operator involved, I don't know what interest the board has in lease ownership or term. But I'll leave that to you guys.
Yeah, that was a follow-up question I had, but before I get to it, Marty, you had a comment.
Well, yeah, no, I think Chris is right on that. And that would be the condition I would be looking for in this decision, that it always be operated by a licensed daycare operator, period. But I would note that what strengthens that a little bit is the latest thing that just came in today from Evans Huber. He wrote in today's submission that I don't have it in front of me, I forget the language he used, but he makes it exquisitely clear that the operator is going to be Needham Children's Center. He leaves no doubt about it. Now, that's not the equivalent of having a lease, but he's really quite clear about it, for what that's worth.
It's true.
So if that's the representation, Chris, can we make that a condition?
That the operator of the facility is always a licensed childcare operator, or that you want to see
that the initial operator is the Needham Children's Center. And then we have our usual condition about what needs to be done if they're transferring it, which is basically they just have to come back and tell us that they're transferring it to another licensed operator. We can't have any discretion on who that licensed child care operator is. We just need to have them come back and tell us this is the person and show us their license.
And provided that they're obligated to abide by the conditions of our...
that they've read and certify that they've read the permit or they've read the decision, and they agree to abide by its terms.
So what
Lee, do you think, have you got enough now to draft the decision?
Lee, you're muted.
Muted.
Lee, you're muted.
Is this what I hope to
I
accomplish?
think I have enough to start it. And I can, we can put some time on the agenda. If I have some, then I can kind of, if I have any questions when I'm working on it over the next week, I can check in with Chris and I can put those questions to you at the next meeting. And then finalize the draft for the meeting after that.
Mhm. Okay.
All right. So
Are we under a deadline from the end of the hearing to make our decision?
You're under a 90-day deadline.
Okay.
90 days from when?
The date the hearing was closed.
Chris, thank you very much for preparing that spreadsheet. I think, as we've talked about before, that was going to be a useful work product. And I think it has been for all of us. And I'm grateful for your taking the time over the holiday to work on this thing.
Anytime, happy to do it.
Thank you very much. Mr. Chair, I return the gavel back to you.
Let's get Natasha.
Yeah. I'll
Yes,
send her a text.
let's get Natasha. We can let her know that we've got headlights going into her house.
We've got to figure that out, guys. Here comes Natasha. There she is.
Natasha.
Sorry, I was blinded by the headlights.
Blinded by the light.
Welcome back, Natasha.
Thank you.
All right. So we are up to consideration of zoning to allow brewery use in Needham. Lee, you have the floor.
Yes, so I just wanted to put this back on the agenda because we had a long conversation, I think, about next steps on brewery uses. And I did have a conversation with, Dave Roach, I think after the board last met, about, where we landed. And, I think we had talked at that time about trying to, fit the use into some existing uses within the zoning framework and make some findings that we found it, for example, to be similar in kind to a manufacturing use. And Dave and I both had some concerns about approaching it from that way because it really doesn't quite fit as a manufacturing use, even though there's going to be maybe manufacturing and bottling. These uses are often associated with retail sales happening at the same time. They're associated with food uses. They're associated with tasting bars. And the towns that I think oftentimes look to as examples about how to craft zoning, Natick, Framingham, Cambridge, for example, have all basically addressed breweries head on, kind of defining the different types of brewery uses and then identifying the zoning districts where they're appropriate. And so I think I spoke with most of you on this. I was just going to suggest that during the course of the next month, I'd be allowed to kind of explore what other towns are doing and come back to you with some recommendations in terms of how zoning might be approached in Needham. Dave Roach had wanted to meet with you to talk to you directly about his concerns and why he thinks it's important that we kind of address it directly through zoning, but he's out for the month of January. But he will be back the beginning of February. And because we talked about trying to accomplish something, I think before the annual town meeting, I was reluctant to just let January float by before Dave could come in and talk to you, because I don't want to lose the opportunity to do zoning in the spring if that's where we land. So I'd like to be able to put together, the approaches that other towns are doing, look at some definitions in terms of how the uses have been defined and some ideas about what kinds of activities might be appropriate in what Needham zoning districts, and then kind of basically put it back on the agenda for our first meeting in February and invite Dave in, and we could have a conversation about different approaches that might be appropriate for Needham.
Adam?
Thank you. I look at this in a couple of different ways. First of all, Marty, you raised a very considered, thoughtful point that you years ago revised the zoning bylaw to include to simplify the process so that someone coming in with a use that's not as clear would be able to do so without coming before, the planning board, which I think is a laudable intent. And yet I think that there are so many different other places in the bylaw where, like, bottling is one section in some places, but not in other places. That where this is really seen as an economic development driver, and we're looking at this effectively in some ways from a marketing point of view, that I think the best move for the town is to be able to articulate very clearly what uses are permissible in which districts, because there are different types of business models, and I think we could fairly easily identify different uses and different sizes and dimensional requirements in different districts, prohibit it in some and allow it in others, either by right or by special permit, which is something that we can all agree on. And I think that would be a very helpful tool for our economic development manager to work with site selectors so they recognize Needham as an opportunity for all of us. And in the meantime, if we get an application, we can certainly consider it, but most of these uses will probably with food require coming before the planning board anyways, and or for parking waivers or other factors. So I think if that's already likely to happen, that our best move, and I would like to see, is to clarify the zoning bylaw and to do it in time for the May town meeting. If Marty, I guess you and Jean, and I guess probably Paul too, are are satisfied that approach can be helpful. I don't see how it would hurt us, and I see how it would help us if we were to clarify it a little bit further than how it's already laid out in our bylaws.
I think it might also, help us, even looking at Highway Commercial 1 that we recently just rezoned, to perhaps open up that use in that district as well, as we're looking at a redevelopment on the Muzzy site. And if we just kind of rely on the way the zoning is currently written, I don't know that it opens it up in that district.
Well, I think there are two locations we should be keeping in mind for this economic development tool. And I think one is mixed use 128, because there you do have, we're not a town that has those wonderful big old industrial buildings along the river, but we have some old industrial buildings in mixed use 128 that might be very useful for this kind of thing, and that would attract people to come and enjoy a night out. And it would be a revitalization tool for that area. And then the other is our downtown, which is kind of a restaurant center for the region. And I think we should build on that. So I think, to me, it's not so much a site like Muzzy's site, which is have to be, it's going to be brand new development of some kind. It's reuse opportunities. And those are the two places where I see that we should be focusing our thoughts. And there may be others. I don't mean to say that's all we should be considering, but to my mind, that's where this tool can really be used. And I think that also makes the idea that, well, we're talking about the downtown and maybe Avery Square and, mixed use 128. They're different places. The uses that we could say, oh, maybe this is similar, and we could say it's okay here. It might not work for all those places. And so I agree with Lee that we have the time. We don't have somebody knocking at the door right now. let's really come up with exactly what we want for our zoning bylaw. And I certainly think reviewing, as Lee proposed over the next month, that she would do this work of reviewing what other cities and towns have done, and then looking at the models is great.
I agree. I think it's an opportunity for us to plan. And I think it's a time for us to, we may not know exactly where these things are going right now, but with Lee's information, I think it'll be really beneficial for us to plan where we want this to occur and to have kind of a bigger voice about it. And I understand, I agree, Marty, with what you said before, that it's open-ended, but I think others may not read it that way, and we may be losing opportunities. So I think clarifying it a little better, I think would be beneficial for the town.
Marty, you have anything to add?
Me?
Yeah.
Since we all said your name, and
Oh, yeah.
Yeah, unless there's another Marty here.
If people want to go through this effort and think that the predictability of having it actually written into the bylaw as to what the possibilities are and where, and to me, that's the best argument for doing it. If people want to do that, I'm not against it. All I was really just trying to say was we may not need to do that. A particular user who has a particular thing in mind may be able to get the benefit of that paragraph we added in 3.1, and that's why we did it. I wasn't trying to rule out this effort. And if people think it's worth it, it's fine with me.
So I had a couple of concerns. One is I am reluctant to keep going to town meeting with zoning bylaw changes and then nothing happens. And, you know, it's an arduous enough process to go to town meeting for a zoning change, and the pushback that we get, I like to do that for something that we really know is something that is something that the town wants to do. You know, we can rush to put through a brewery bylaw change, and you know it means rushing through our procedure, having the hearing, deciding which districts we want to do it in, and then having neighbors from those districts come back and say not in our backyard, and then we finally get it passed, and then 10 years down the road we don't even see a brewery in town. You know, and that's a concern that I have. It's like I want to go to town meeting if I know it's something that this is something that is going to, a change that is going to happen in town. Like we did with Muzzy. You know, we've been to town meeting before my time, but we've been to town meeting twice in order to try to revitalize Chestnut Street. And how long has it been? 20 years? So, you know, on the other hand, on the other hand, going with Marty's looking at the similar use, that's a bit of a problem, because the districts that allow for manufacturing or allow for bottling, and then there's a question of, well, is this manufacturing? What is it? Aren't necessarily the districts where we want this to happen. And that's number one. And number two is that where manufacturing is allowed, it's allowed as of right. And I think this is something, especially where alcohol is involved, even though they have to go through the process with the select board, I'd like to see this as a special permit situation. So, you know, I've got the one hand not wanting to go to town meeting every time somebody comes up with an idea, gee, why don't we zone for this in town? Why don't we zone for that in town? And
This is,
so those are my thoughts. So, and basically I'm saying, let's proceed with what Lee wants to do. Let's see what other towns have done, use them as a guide, have our meeting with Dave Roach. And, it'll be the middle of February and we'll see where we are and what we want to do. Adam?
I was just gonna say as an additional item that related to this, that brewing is not a simple thing. You have to go through the Federal Department of Alcohol, Tobacco, and Firearms, and in order to be able to actually manufacture alcohol, in addition to getting a state license, in addition to applying to the local authorities, in addition to getting some kind of securing a site. The first part of the process in order to commence the application with ATF is site selection. And so anything that we can do that simplifies that process and provides a kind of clarity for a business to be able to, to go down that road is ultimately very helpful for an applicant. That's all I'll say at this time. And I think, Lee, that will be really helpful. And if you need a tag team on, someone to help with this, I'd be happy to.
Yeah, I'll be reaching out to you and probably Jean, looking at some text, and Marty.
Right.
Sure.
Okay. So let's move.
Okay, thank you very much.
You're welcome. Board of Appeals. What do we have on the Board of Appeals? I believe there were.
They want to use the church, Episcopal Church, as a daycare for 25 students and 2 staff.
Yeah, an after-school program.
Correct.
After school. Mhm.
And then there's an amendment to an existing application for a demolition of a garage in a single-family house.
Let's take them one at a time.
Yes, sir.
Let's take the Episcopal Church. Does anybody have any comment on that? Or shall we report it, no comment?
I would only say, and I don't know what the extent of our comments should even be on an application like this, but it just seems to me that an after-school program for 25 young kids with only 2 staff seems pretty thinly staffed.
Mhm.
Whether that's something that we ought to offer as a comment or not, I don't know, but that would worry me. I would be careful about that.
I thought that there were state standards that they have to meet if they're going to provide childcare.
Yeah, I didn't look at this too carefully. I don't know what the ages that we're talking about. If you're talking about early childhood,
K
you're
to
right.
5,
for a state-
I think it's K to 5.
Yeah, K to 5. I'm not sure there are state standards on that. I'm just trying to remember back 25 years ago when my daughter was that age, or 20 years ago when she was in an after-school program. I think there were probably 25 kids and 2 staff members. And she had a great time.
I mean,
Well-
I think it's close. So it's roughly 1 staff person for about for 12 and a half kids.
Yeah. Which, early childhood, because we were looking at this for 1688, is a staff member for 10 kids. So it's not that far off. I would recommend no comment. I mean, we've got childcare facilities in churches all over town.
I agree on no comment. The only concern I had was that Rosemary, to get to that site, you go down Rosemary Street, and there's really hardly any parking, and it's a very narrow street. And they say people are going to go and park in the Episcopal Church parking lot, which is where library patrons also park there, and then walk back across the street. I mean, so I think we just leave it to the Zoning Board of Appeals to have appropriate decisions and appropriate conditions in their decision. They can make those conditions as well as we can. But I just hope that works.
I agree. I think I don't have a comment.
I move no comment.
Second,
Motion and a second. Any further discussion? Seeing none. Adam,
Aye.
Marty,
Aye.
Natasha,
Aye.
Jean,
aye.
and I vote aye. No comment on that one. We have a property on the corner of Mark Lee Road and what is it, Alford, where Dave Roach
Alford.
Alfred stated that where they want to build a new garage, the setback didn't work because they were fitting it into a rear setback, and it's a corner lot. And Dave said, it's a corner lot. You've got
Two sides.
Two frontages.
you've got two frontages and two sides. And they're saying, no, where they want to put the garage should be considered a rear. I found it interesting that they got two neighbors farther down Mark Lee Road to write letters saying that they were in favor of the petitioner. And the next door neighbor on Alford, who was most impacted by this, you would think they would have asked that neighbor for a letter if they were asking neighbors for letters.
Maybe they did.
Maybe they did.
Um,
So I'm inclined to just leave this to the ZBA
Well,
and let them have their hearing and see if the neighbors show up and let them decide. Yeah, Gene.
I think it's a bit complicated. Well, first of all, I agree with the building inspector's interpretation. But I think what they had originally with the garage wasn't really a prior non-conforming use. They're not asking for reconstruction of a prior non-conforming structure. It was probably simply that it's an accessory building. And maybe it actually meets the side setback now as an accessory independent building. What they want to do, and I'm scrolling on the site plan now, is they want to attach the garage to the house, to the addition they propose to make to the house. So you can walk directly from a reconstructed garage into the house. And I think the fact that they're doing that makes the garage not an accessory structure, but part of the primary structure, and that has to be set back 14 feet. And I think it's not a question of whether the neighbors like it or not. They're appealing a building inspector's decision, and it appears to me that the building inspector is correct. And what they're trying to do, which they're not saying they're doing, is to apply for a variance. And I know that our zoning board of appeals rarely, if ever, grants variances. But that's the essence of what they're asking for here.
I think they needed to get, I think they were going to get the building inspector's a refusal on it and then appeal his decision and then perhaps file for a variance based on that.
But the current garage is even closer to the lot line.
Exactly.
So they're basically saying their existing garage to be raised looks like it's almost like at one corner about 5 feet from the lot line. And they're moving the proposed garage would be within the 10 feet, which is what they think is the rear setback. So they're actually improving the condition.
You
So-
mean they're moving, the proposed garage would be set back somewhat farther from the old garage. You're right.
Right, so they're improving the condition.
Except that the old condition, I mean, the old setback standard was 5 feet. It's 5 feet, I think, for an accessory structure.
And that's what it is now. It's not prior non-conforming. It's 5 feet now. Is that right, Lee?
Yes, it's 5, it's 5 feet.
Yeah. So they can build a new garage. If they want to have a new garage and have it be 5 feet from the lot line if they want to,
But it would not be attached.
it would not be attached.
However, they're trying to attach it to modernize it, and you know, and they're going to 10 feet. So I'm just bringing it up that the condition will be better than it is today, and it'll be better for them in the house. So
Well, it's a question of precedent and proper interpretation of the bylaw. And
right,
what's before the zoning board of appeals is the building inspector is wrong, but the building inspector happens to be right.
correct.
So as a planning board, looking over the shoulder of the ZBA, what do we want to do? Do we want to give them feedback, or do we want to just say no comment? And let them decide.
Well, I think we should give a pat on the back to the building inspector. Say something about how we think the interpretation of the building inspector of our zoning bylaw is the correct one.
Are you making that motion?
I am. I move that.
Second that motion.
Okay. We have a motion and a second. Is there any further discussion?
I guess would you add to that motion that the proposed garage addition, although it does not meet the zoning, it still is a better condition than if it was an accessory building.
We could, but I think that's going to be pretty clear.
That's not for us to.
That's the kind of thing I do leave up to the zoning board of appeals.
Yeah.
And their discretion.
Do they have any discretion here?
But they don't have, exactly. They don't have any discretion here.
I think they have to decide whether the requirement is a rear setback or a side setback.
And Natasha, I would say that the 5-foot setback for the structure, if it's a 1-story building, it's 5 feet. If that accessory structure were more than 1 story, it would have to meet the side yard setbacks.
Side yard. Okay.
So in this case, I think they're actually putting a second floor on it.
That's right.
Okay.
So
They are. I'm looking at the drawing right now.
Finishing it.
They are. Okay. So
I move
I,
the comment. Yeah, let's.
Okay, we ready for the vote?
Well, the only comment would be the one that has already been proposed, which
Right.
is we think the building inspector's interpretation is correct.
Correct, yep. You ready to vote? We start with Adam,
Aye.
Marty,
Aye.
Tasha,
aye.
Jean,
Aye.
it's unanimous. I vote aye. And the third one is the demolition.
we've already commented on that.
We have, it's a yes, it's a continuation. So that's done. Okay, so the next item is minutes.
I move that we accept the minutes of November 8th, 2021 as presented with the redlining.
Second.
Any comment? Any discussion? We'll take the vote. Adam,
Aye.
Marty,
Aye.
Natasha,
Aye.
Jean,
Aye.
and the chair votes aye. It's unanimous. Report from the planning director.
Yes, thank you. I need your input on 2 projects. I think I started to talk to you about these at an earlier meeting, and it was so late that we really couldn't focus on it. So the first one is a proposal that Dave Roach actually received from Dunkin' Donuts. And they were interested in constructing a building that would not allow anybody to go into it or sit in it. It would just be a drive-through place where you could pick up coffee. So Dave's interpretation of zoning was that a drive-through was an accessory use to a principal use. So you could have, a McDonald's and you could have an accessory drive-through, or you could have a bank and you would have an accessory, maybe cash window associated with it as a drive-up. But that as a principal use, a facility that was dedicated solely to drive-up, which provided for no service within the building itself, was not allowed as a principal use.
Mhm.
And I just wanted to confirm that with you, because Dunkin' Donuts said I guess there's some models out there of Dunkin' Donuts that are done more traditionally, like on a highway location, where they just stick a building up, and you just drive up, get your coffee and go on. And they were looking at doing it on a location on Chestnut Street. So David, in my interpretation, was that it was, if you had a facility and they wanted to have a drive-up window adjacent to it, then they could get a permit for an accessory use, where they would have the primary store there. But just to have the drive-up without the primary store there was not permitted or envisioned in Needham's bylaw.
So were they looking to demolish their building now and redesign it so that it was just a drive-through operation?
No, I think they were looking at the bank location on Chestnut Street initially, and they were trying to pick that up. And then that didn't work. So then they thought, well, can we just, take a portion of that lot, as how I understood it, and just put a building there and just have a drive up by it.
And keep the existing Dunkin' Donuts on Chestnut?
I don't know if that was going to be moved or not. I don't know. I think the only thing that was put to me by Dave was the question about, would it be okay for them just to have a standalone building sitting on a lot someplace with a drive-up window to it as an independent use?
I mean, we've allowed that sort of thing in essence now in this COVID era, because restaurants aren't having a sit down often, and the only thing they might offer is the drive-through service. But that's certainly not our vision for what we want for Chestnut Street in the long term.
I didn't think so, and I didn't think the use was allowed as a principal use.
Mm-hmm.
I can't see where it fits into any of our use categories as a use that's allowed.
Just a drive-in operation on its own. I have to go back to the bylaw. I don't remember at this hour. It's 11:30.
No, but we'd have to pour through the bylaw, but I don't recall seeing anything that even.
No, I think when we've allowed for a drive up, it's been as an accessory to a principal use. So when the bank, put their drive up facility behind Needham Bank, that was done as an accessory drive up use. When McDonald's did it, was as an accessory to their principal use. It wasn't a standalone use that you had without that principal component.
Right.
Just the one comment is that it does speak to, it may speak to the future of, of this kind of retail.
Yeah, but what we're saying is, Adam,
that it's not allowed.
We're dealing with a question of what do our current bylaws.
I understand.
If we're, if we're going to, it seems that if we're going to allow it, unless Marty, you think that there's a similar use that falls within 3.1, and I can't think of one.
We thought of 3.1 again, that paragraph. If they want to come before us, explain what the impact would be and whether it's the same as similar, I'd listen.
But again, I don't want to go to town meeting with, all these zoning amendments.
Well, is a drive-through facility along Chestnut Street what the plan calls for along that corridor? I mean,
It's a highway-oriented use. It's not the Chestnut Street type of use. However, I'm remembering something we approved not long ago And it was either off Gould Street or off Riverside Street. And it was basically the primary use was a caterer. And he wanted to be able to offer pickup lunches. And we said, yes, that's okay. Didn't we do that?
That was a temporary COVID allowance.
Yeah, that's
My
right. Yeah.
recollection.
Yeah.
I don't think it's a fair characterization in the world of commercial real estate, especially retail, to say, Gene, that this is actually a highway use only. It may not be currently, based on how Chestnut Street has been laid out, but that doesn't mean that the use is really limited to highway purposes.
Depends on what your vision is.
Now, when Gene says highway, I'm thinking of like Route 9,
Yeah.
not Mass Pike Highway, but like Route 9, or even like 135 in Natick.
Well, people never walk. I mean, they don't walk from place to place. You drive from place to place.
Our vision of Chestnut Street is that it be a walking.
I understand that resonates.
Yeah, but how's that working out though?
Yeah, exactly. That's what I said before. We've been to town meeting twice already. And if Ted Owens was still on the board, we'd be going to town meeting a third time.
I don't have a problem with that. I think that's our job, by the way, but that's just my personal opinion.
Okay, then I'll move on to the other one that I had, and we talked about this one earlier, and we never landed at a solution. And this was Starbucks, I think, approached Dave and I, because they wanted to put a walk-up window, actually, on their store in the Heights. And so the question was, well, this walk-up window, which they were going to put on this, what street is it? What's the cross street there?
West
Street, that they were going to put it on West Street. Is that Dave was concerned about how that should be managed, and whether or not that walk-up window was envisioned or allowed under our zoning. And so if we treated it like an accessory use, which we talked about doing, it would be treated differently in some districts. In some districts, those kinds of an accessory use of that type would be by special permit. In other districts, it would be by right. And then there was some concern. In this case, it would be by right, even though we hold a special permit at that property. But there was some concern about how would it functionally operate? People have apps, they can order their coffee. I mean, would they really be walking up to this window? Would they be ordering their coffee online and jumping out of the car to pick it up when the light was red? So, I mean, there was some concern about actually implementing it at that location. So Dave was reluctant to treat it, as an accessory use that was allowed by right. And he thought the board needed to address it from a broader perspective. But I need some direction from you in terms of how you want it approached.
The frozen custard place in the center on Great Plain Avenue has a walk-up window.
I know they do.
I was going to mention that, Jean, as well.
Yeah. And
Abbott's.
how was that allowed?
I think that
remember
was just probably allowed as an accessory use.
Yeah.
To what principal use though? Like that's all it is like you can
Well, it's
go
an ice
in.
cream store. You can walk into the store too.
Yeah.
Right.
And at Dunkin' Donuts, I mean, Starbucks, you walk into the Starbucks, presumably.
Right.
Yeah.
I mean, I think part of the question with Starbucks is how really is it going to function? I mean, the ice cream store, it's right in the center. You do walk up, you wait for your ice cream. Starbucks has their app. You can order your coffee online. It's ready when you get there. Is it really? Are people going to park and walk up to this window, or are they going to?
What's to stop Abbott's from developing an app?
Right.
Yeah.
Mm-hmm.
Yeah. So I guess that's my question to you. How do you want it? How do you want that managed? Do you want it? I mean, technically, if Starbucks wants to do it, because we hold the site plan on that property, even though that accessory use is allowed by right, they'll have to amend their site plan. So they'll come in front of you and ask permission. And you'll be able to decide if you're going to let it happen and how it's going to operate. But
As an
once
amendment-
that
as an
decision is
amendment
made
to
for them,
their
then it's universal.
Site plan approval as an amendment to their original special permit. Is that right?
Right.
Well, yeah. Well, that's what we do, right?
What's wrong with
Right.
that?
Do we need to say now what our decision would be?
No,
just-
no, I just
no.
want to know how to manage it.
We'll have them come in to amend their site plan
Okay,
or to amend their special permit.
okay.
And then we can
Reminds
ask
me
them
of-
how, you know,
For 1 year, I had sold my house, we moved to the Heights, but I was still commuting into Boston on the train. And I would go to Starbucks every morning to get my coffee to drink on the train. There are a lot of walk-up customers to Starbucks who are heading for the train.
That's right.
yeah,
Oh, so maybe so in the Heights, you think that might be the case too, then, going to the train, walking past it at that window?
Yeah.
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 Okay,
And I lived in the center. I would go to Bagels Fest, get my coffee and then get on the train, you know.
okay. I guess I'm not, I wasn't as optimistic as you were. I was thinking about what I would do.
That is, to a large extent, that is a walking area. And,
Avery Square,
yes,
it is.
Yeah.
Okay, so that's how I'll process that.
yeah, okay,
And I
that's
think
it,
that was all I had.
okay. Any reports from any of the board members?
I know. What do we do about this communications that are still coming in about the former
88.
the property at
That's right.
888 Great Plain Ave? We just sort of save them until the time comes.
Yeah, until I put George on the agenda, I think.
Yeah.
He wants to come back and talk about that zoning issue. Oh, I just remembered, we advertised for the vacant position on the design review board. And we got one inquiry of a person that doesn't have the skill set that we're looking for. So, if anybody knows of a landscape architect or somebody trained in horticulture that you feel would be a good candidate, for the design review board, it would be helpful if you could reach out to them. Because we
That's-
advertised for this, it's up on our webpage and we haven't heard anything. So then it's open, it's an open seat.
And they either have to have their business domiciled here or they themselves are residents here. Is that right?
I thought it was for a resident, but I think it's a resident.
Yeah, I
So-
think you have to. I would think you'd have to be a resident. Yeah.
I think I know of someone. I'll dig them up and give them a call. Not to say that they're below ground, but I just mean that I'll dig through my memory and find them.
Okay.
Lee, the transportation committee thing?
Oh, yes, we need an appointment to
yeah.
the transportation committee.
I
Oh,
nominate
so
Dean.
busy. Gosh.
We looked
We
at
can
this.
appoint some,
Lee and I looked at this. It does not have to be a board member. It's just someone appointed by the board, not someone selected from the board.
Hmm.
Other committees in town, they have to be a board member, but not from us. And Adam, you had sent an email about somebody who you knew.
So Justin McCullough is already on, I think, Team. I think he serves with your husband, Gene.
He's on both of the committees, or I guess there's 3 committees being considered for reorganization, and he chairs one of them. He chairs the Traffic Management Committee, and he is the secretary of the Transportation Committee. So he's already very much involved. So I don't know, it seems odd that he wouldn't
be.
already be involved in this transition committee.
well,
I
there's
can-
one current representative that's appointed by the traffic management committee. They have a representative on this group.
Do we know who
They
it is?
do.
Is it Justin?
I don't know who it is, but they're, at least the composition.
And
indicates
so
that there's a,
David.
And I imagine the
Montgomery-
transportation committee too, no?
it's, yes, for the transportation committee and the traffic management.
And the
advisory.
traffic man, and he
Both-
serves
both
on
have a pro-
both. So if he
Both
wants,
have a member that sits this part of this group.
yeah,
Folks, it's 11:35.
Okay,
oh gee, I'm trying to, but none of us, just to make it clear, I mean, Natasha and I are already serving on the Housing Plan Working Group. Paul is serving as chair, and that leaves Marty and Adam, who aren't like overburdened right now.
Well,
I'm-
Gene,
I'm only going to be here for 3 months, and this is a
Yeah.
6 position.
I'm vice chair and I'm also chair of the CEA.
Yeah, it's just not possible.
Let's try to think of somebody to appoint since it doesn't have to be somebody from the board.
Yeah.
I mean, it's a 6-month thing and we don't know how frequently they're meeting. It's more than,
Or we could be like the ZBA and just refuse to put somebody on.
well, I think this does require some degree of planning. Lee, we can chat about this maybe tomorrow after
Okay.
dinner or something.
okay, fine.
Yeah, I'll think about it. If I have any ideas, I'll certainly share them.
Can I have a motion to adjourn?
So moved.
Second.
Any discussion? Adam,
Aye.
Marty,
Aye.
Natasha,
Aye.
Jean?
Aye.
Chair votes aye. Good night, everyone.
Good
Good
night.
night. Thank you, everybody.
Thank you.